is that it was a clear mistake.
Again, that's, you know, everybody's entitled to their opinion, and I respect yours.
Yeah, Dan, I'm
I just wanted to
blaming anybody. We're saying this is what happened. Should we fix it?
Right. I just want to know if it was talked about to the planning and zoning, and if it was recommended to you guys to make this change from them, because they're the ones that have to deal with this, right?
And again, I don't know that it was an error in 2020, you know, because just because they potentially or allegedly might not have seen the fact that transportation terminal is listed as an accessory use in the RA district, I mean, I think there's reason for it to be there. And we have business owners here tonight that support the fact that it's there as an accessory use.
And you were on the board then, so.
Right, I know.
So I'm just saying, you don't remember.
What are you saying?
I'm saying maybe there wasn't enough discussion then when the decision was made.
I don't remember. I know there was talk around a transfer station. A lot of people that came to the board wanted a transfer station. We reached out to a bunch of towns. Everybody said, don't do it yourself. Have somebody come in and do it, collect the taxes. Bethlehem has one. Cooksaki has one. We thought it was a good idea to have one in Queens. But it never happened, so. But again, let's leave the past in the past, right? Let's focus on today. And I just want to know where this is coming from.
It came from a legal perspective. We thought that there was an error in there, and we gave it to our legal department to look at, and they looked at it and came up with a determination, which.
Did any of you guys reach out to him asking about this?
Not me.
I had a
I
conversation.
think Mike found the.
At one of the, I forget what it was. We had a meeting, and after, you know, it could have been something with the Fast New York grant. I'm not sure, can't recall. But, you know, I had a conversation with Linda and Steve, I remember, in the back room, and just said, you know, I really feel like we should look at, you know, some parts of the town code to make sure if we're going forward with something like this, let's make sure that, like, it's safe for everybody in the town. And, you know, Mr. Riley said, I'll look at your town zoning, and, you know, it came up. A couple things came up, actually. So some things stuck out. He brought to our attention, and for the last couple months, it's been sporadically talked about a little bit. But, you know, and Dan, we're not talking about really the transfer station part of it. It's the transportation terminal part of it, right?
Oh, I know.
And I looked in a lot of different towns, town codes, and, you know, from all around the area close to us, and I only found 2 transportation terminals. One with Bethlehem, and I think one was Saugerties, and they're both in commercial and industrial zones, and they're both for, like, you know, public transportation, like CDTA buses, stuff like that.
Okay.
So again, we're just trying to figure out a good definition to, you know, protect every zone appropriately.
And you guys are going to send this to the county for their opinion and their review?
They deferred to local consideration.
Okay. So you already sent it then? Okay.
I don't recall seeing that decision, so if you could pass that along, that'd be great.
Again, the only thing I'm going to say is this concerns a lot of people. It affects a lot of people. Just take it slow, right? It seems like all of a sudden this really wasn't talked about. And now all of a sudden here we are for the first of the year, and just take it slow, right? You're shaking your head no. It was talked about?
No, I'm saying, yes, take it slow, and we're not in a hurry to make a decision, honest. That's not our intention.
Well, you have a law already written out.
I mean, that's how the process.
Information.
Circulate a law, you
Right.
send it to the county, you have the public hearing.
You gotta speak up a little
All right.
bit so people
Thank you.
can hear.
I had no intention of speaking right now, but you just threw me under the bus, so that's. I'm Tricia Grogan. I am the chairwoman on the planning board, resident, other titles, but anyway, no, this was not brought to the planning board, and I actually read about it when I looked at the agenda and whatnot. I knew it was sort of coming down the pike. I didn't know the details about it. And today, my first question was, why wasn't the planning board even questioned or consulted? I think everyone here knows I went through a horrible situation with a trucking terminal where a different board put a moratorium on it. Again, no consultation with the planning board, and it made my life worse. There has to be some kind of communication. And I'm not saying that the planning board will have an end all. recently, again, everyone here is aware of another pretty contentious application that I just had in reference to an RA zone with something agricultural. And the thing that came out of that, our zoning is so antiquated. Why are we taking one piece and piecemealing? We need to look at our entire zoning. We did that one piecemeal when it came to the long energy situation. It was horrible. We're trying to do it again. We need to look at our entire zoning. Whether we have a workshop, instead of putting laws through without having workshop, without speaking to the public, without asking them, who better to ask but farmers? Farming is not what it was in 1963, which our zoning laws are from. Farming was not what it was then, what it is now. We need to be mindful of our businesses, of our farming, and of our residents. We have people who are in the RA zone and they have a small farm, but it's residential, agricultural, but they have some kind of business. We need to be mindful of this entire big picture. No, I don't think anybody here will disagree with you. We need to look at our laws. We need to change zoning. We need to update it, but we need to come together and we need to look at other towns. We need to look at other codes, other zones, work with other attorneys, not just one attorney, and go from there. So I really would have loved to know a little bit about this before I found out about it in the agenda. Just being the chair of the planning board, it would be helpful.
We will have further discussions too, probably on the 24th at our next meeting. So this is an introduction.
I think you'll find that I've said that all along in several meetings, that I think that we're piecemealing this process, and I've said all along that we gotta look at the whole thing. We gotta stop looking at one thing, and it's just been, I feel it's just been drilled this one.
Well, piecemealing makes
Yes,
more work and
problems.
harder work for the
Because I think
planning
there's,
board.
and I think we've had this conversation before, there's so many unintended consequences by piecemealing. And one problem, if you try to fix it, it starts another problem, then it starts another problem, and then we just keep throwing money after money after money, changing crap and all that. We're gonna get more lawsuits and stuff thrown at us and other things. Let's just do the whole thing, one shot, and let's
It needs to be done.
address this issue and this topic in a whole review of the whole thing. I agree with you. I've said it several meetings for months.
And I think the reply was that the town is exposed right now, and we are looking at farms and industry, but the town is vulnerable right now.
And I think we
Like I
open
said,
up,
the
make
anal-
ourselves
the
vulnerable
analogy
by doing this
that we would
process.
say, because we're getting the hodgepodge comments, we're doing this piecemeal. But the issue is, if you get a flat tire on the side of the highway, you're not gonna start saying, well, I need to rebuild my engine. You wanna fix the tire and then take care of the rest of it. There is a larger picture that we have to deal with, and we are going to deal with it. That is going to come, but that's a long, lengthy, expensive process. Right now, we're just trying to secure the town because it's exposed right now.
And I don't disagree with you. So the one thing I will agree with you on is you're right. We recently had a flat tire. And that was for the RA zone for an agritourism situation, not this. So maybe we should look at that situation then instead of this situation. So that's just, this situation has not come towards my board at all. This has not been an issue. I have had a recent issue for planning events and weddings and stuff like that. So maybe you table this then and bring that up because that's coming more down the pike than this.
Well, actually, if you want to go back a couple of years, we were pretty exposed when GE Verona was trying to come in at the port. It was a very huge project, and we weren't prepared for that. However that came about and how that started to fall apart is a whole other story. But right now, we're just trying to protect the town as we go further into it by by discussing the terminology and the definition of transportation terminal and agricultural transportation terminal. It's all we're looking at right now is having that conversation.
I guess if it's just discussion and you're not acting on anything, but I heard that there's a law that you guys are gonna have to decide on at some point. So that is a little, why do you think there's so many people here?
And
But you have to create a law in order to send stuff to Albany County. I mean,
the
for the process. You can't just say, we're thinking about this, Albany County, what do you think? You have to send
But now we're-
paperwork to them.
But now we're hearing Albany County saying defer back to us, so,
Well, I mean, we didn't know that.
okay,
Sorry.
I don't know anything, so.
Time is
Ladies and gentlemen, this is the existing zoning ordinance from 1961. Notice both sides. I keep that because that's where the town was forced to go back after the last attempted zoning ordinance was sued and cost the town a ton of money in legal fees because it was poorly done, and it got thrown out, and it got sued to Ms. Grogan. My name is Tanike Powell. I live on Bronx Road. My family's lived here for a while. And I regularly have to come down here and defend my property from the town government, from the state government, from others who have designs on my property. I love where I live. I could live any place. I could live in Queens Hall. But I like where I live. This is shocking to me that this is the first law of a year that's almost over. And this is the law that's brought forward. I'll be frank, the board received a letter from me today. Ms. Grogan, I sent it to you. There is only one reason why this is here. And that's because Mr. Stott pursued this. And that's why it's in front of Mr. Riley. Mr. Riley, my lawyers took a look at it and said, there is no mistake made here. You can discuss that with them if you'd like. I'd be happy to give you their information. But for me, as a landowner, there was a law in place for 60 years here. As a matter of fact, Mr. Stott's great-grandfather or grandfather-in-law sat on this planning board. There was no contention about it, but the property had two zones. On that one deed, it would go to the lowest zone. I went to Mr. Stott's house, did I not? And I told you that that was the case in your kitchen about how the zoning law worked. You were new to it. Why would you ever look at it? It was because Carver cleared the trees on my father's place next to it. Understandably, and I'm glad you did, because it's good. Because maybe something that will get done here will be exactly what Ms. Grogan said, which is revise the zoning ordinance. I was on the zoning board 30 years ago. We tried it. We were crushed because we didn't take into account the people here who are farmers and rural residential agricultural people. I'm in a different situation. I am on farmland. I currently have some of my land in agriculture. I make no money on it, $0. By not having this one thing, it restricts what I can do with my property. I have no plans currently. Everybody who's in this town knows that various people are interested in doing things with my property. To date, I have nothing going on there other than collecting tires, which Carver Companies very graciously helps me with as my neighbor. But frankly, ladies and gentlemen, to have this come up for one law to restrict people, the rural folks here, the farmers, this greatly impacts them. There's no consideration given to this because it's not about them. It's about Carver and it's about me. I'm used to it. But that said, when the change happened 3 years ago to take away that law that gave me that dual zone, there was no reason to chase that prior to that because everything I had could have been considered industrial, yet it wasn't. Why is that? I didn't want it to be. I'm a good steward of my family's land. Our family ran a brickyard here for 100 years, and we didn't trash the place. So I would hope that there'd be some consideration for not only the people who are farmers and actually trying to make a living of it, but that we would consider the people that are also here. You've all seen the map of my property. I have a tail of property that's zoned residential. In that residential piece, it is surrounded by industry, right? Completely. Now, this could all be resolved. For everybody, there are about 700 acres of R1 zoned land. They have been since this. This would all be R1 zoned land if there was town water and sewer. The town of Queens has had 65 years to do that and has not. That's how you can resolve it. Bring town water and sewer. The people of North Queens would be thrilled with that, I would think. Maybe not. I don't know why they wouldn't. The water up there is terrible. But that's how you can fix it. But trying to nickel and dime it for one person's need on a board, we've seen that for decades. Not just from this board, from other boards as well. It's wrong. It's unethical. It is your right to be able to do that. You can stay here tonight, you can vote, 3 of you, up and down, and it's done. And it's the same unethical stuff that's been happening that many of you ran against, and you need to stop it. All politicians need to stop it. So, having said that, I strongly urge you not to vote for this tonight. By the way, this is not a draft. This is the real thing, because I went to the town hall, waited for the draft to be completed, and then got the final law. So this is proposed, and it can be passed tonight. Thank you, Mr. Donnelly.
I'd like to say a few things. In rebuttal to that, I don't think you're really restricted that much, Mr. Powell. I mean, according to your property, you do have some industrial land. If you want to do something industrial on that industrial land, by all means, go ahead and go through the proper channels. But you have a lot of agricultural residential land, and according to the schedule for zoning regulations, there's plenty of things you could do to make money off it. I mean, you could plant stuff. You could, you do hay it. I'm sure you don't get paid for it, but you could surely plant stuff. You are not restricted and penniless because of whatever's happening here. What I will say though is, let me read, because after it was changed in 2020, after it was defined in 2020, a few months after that in 2021, the town board accepted and approved, wrote down a comprehensive plan for the town. Now, again, if you don't know what a comprehensive plan is, it's really like the footprint that the town is going to follow from here on out. It's like the pathway we want to follow. So, a very important part of that comprehensive plan reads as follows, and I apologize taking your time, but let me just read it. It says, and it talks about like economic growth and opportunity, which I'm for. It says, while, growth at the Port of Queens, the industrial park, and other areas, while it can happen still, it provides many opportunities to the community. It comes with many challenges as well, including the balance of residential, commercial, and industrial growth, and protecting the health and safety of residents and the environment. The environmental impacts of industrial growth should be considered to ensure the best quality of life for all members of the community. To ensure this balance, industrial development should be directed to only existing industrial areas and maintain a substantial buffer from residential areas to maintain the character of existing neighborhoods. Currently, there's still room for growth within the industrial zoning districts. Additional industrial growth is only intended to occur within existing industrial areas. No geographic expansion of existing industrial growth districts is recommended at this time. So I keep saying it's a mistake that they made a one-size-fits-all definition, because why would you purposely define a transportation terminal that way in that even mentions, if you took out the word port from the definition of a transportation terminal and you said, hey, Mr. Stott, define a port for me, I would be coming up with things like, maybe a railway terminal, a freight station, container terminal, a yard, a transfer station, a receiving point. So the fact that they, did this one-size-fits-all, I think it's a mistake, because why would you do this and then 8 months later come out with a comprehensive plan for the town that's updated and have that in there where like no industrial expansion should be done whatsoever? Because to me, this is a loophole that leads to industrial expansion. And how about, it shouldn't, we should try to maintain the character of existing neighborhoods. I understand there's probably profit for you in this, but for the rest of the people, maybe let's say North Queens, you haven't talked to anybody, Carver hasn't, nobody on the 2020 board did, but I've been around, I've talked to people, and I've talked to them about like how this could be dangerous and if they would like to maybe see it redefined to be more specific to their zone of R1RA, and they all agreed with me. So I'm not taking this as a shot at you or a shot at industry. I'm trying to do what the comprehensive plan says, and that is to maintain a balance, which I believe that this definition does not do specifically. It's hard to have a one size fits all of like, we're gonna have this definition for 3 industrial zones and the same definition for agricultural zones. To me, that's not correct. And whether the definition that we currently have to be proposed, like an agricultural-based definition is correct, I'm not sure. But I do believe that this current definition for the agricultural zone is incorrect.
Did you reach out to anybody in Queens Hollow when you were doing that stuff?
No. Did you in 2020? Did you when you created this
I didn't
definition?
say, it's your story, not mine. No.
I didn't, Dan.
You work for everybody in the town.
I have not pulled the
We
town.
did-
I have
we
not
did
pulled
reach
the
out
town yet, Mr. Baker.
to
I'm sorry.
businesses.
I don't know why it always
To
turns
answer your
into an
question, we
argument
did
with
reach out to
somebody else's
businesses in Queens Hollow, and Mike is,
That's all.
he's dealing with his constituents in North Queens.
All those constituents of the
But he
town.
has all of them here.
Right.
I'm sorry for interrupting, I do apologize for that. Every one of you has everybody in the town of Queens.
That's correct.
It's not just for North Queens, okay?
And I-
Every one of you, and you guys were all elected. There wasn't a North Queens, there wasn't a South Queens, there wasn't a Queens Hollow.
We understand
All those
that.
were counted.
He went to his
That's
neighbor,
silly.
he went to his neighbors, it's not silly, he went to his
That's a
literal
silly statement
neighbors
is what
and
it is.
spoke with them.
That's a silly statement.
It's not a silly
fraudulent statement, it doesn't make any sense.
It makes absolute sense. He went to his literal neighbors, knocked on their door and spoke with them.
But why
and
didn't he
listened to
come,
what they had
but
to
why
say.
didn't he come speak to local businesses that this would affect?
Well, that's
They
what
didn't
we
even-
reached out to.
They didn't even
He
We
didn't
reached out
use
to
local
Collins, we
businesses
reached out to
You didn't
Petropoli.
come see me like you had the pleasure of going to see
to them
me.
until I brought that up.
And that's what we're having right now.
Do Ms. Collins, or maybe I should talk to Zach, I don't know, but,
I'm here.
okay, I know if she's involved in the business or not, that's all, Zach, thanks.
Ma'am.
So, Ms. Collins, does the Collins family, have they applied for a transportation terminal, and do they utilize that?
So if this was in law when Collins and Sons started, we would not exist.
Right.
Okay, so my perspective, this is all I wanted to say when I got up here, was I wanted to reiterate what Mr. Lucan said, is that I don't believe this is a mistake. I believe that this is to protect farmers specifically, because while farmers buy excavators and trucks and things for agricultural needs, we would not survive if we were only allowed to use those things for agricultural purposes. So we then use our dump trucks and excavators for non-agricultural purposes as well. So I believe the law is written like that to protect farmers, because we can't just survive on agriculture. That's all I wanted to say.
Thank you. Any further public comment?
I just have one. Has this affected any businesses in town, the law as it is written now?
Has it affected any?
Yeah.
It hasn't, I don't believe so, no.
So it's not
Because
broke.
a lot of the, for example, a lot of the places that we're talking about, like Collins, they are pre-existing non-conforming. So they don't really use it, and I understand, like, that's not speaking for the future. I understand that.
Takes the opportunity away.
I would say,
Well,
It does.
okay, but I on devil's advocate, I would say, so you don't think that this current definition, you don't believe that there's something odd, the fact that it's a definition for a transportation terminal for 3 industrial zones, but the same definition for a agricultural zone?
but has it hurt anybody?
I just said because.
Has it done any damage to any businesses as it is right now?
To businesses now, no, it has not.
So if it's not broke, why
but-
fix it?
What I guess the issue, Ms. Tanner, is there's worry that this could provide a loophole that could allow just what we were trying to prevent happen over the last several years with various administrations, and that's industrial creep. It's trying to prevent the fact that this creates a loophole that now industries could say, well, we could use this definition to sort of get our, our industries into agricultural lands.
I understand where you're coming from, Mike, and I
Right.
I know it's a big job, but like she said, let's do the whole thing. Don't just nitpick. There's more important things right now on our agenda than this.
I don't know if that's necessarily true. I mean, we have a lot of things on our agenda, but this is an important thing
I
that's.
understand, it is, but I'm sure there's other things more important.
And I don't think necessarily we're nitpicking. I mean, for example, it's, under, before your administration, didn't that town board in 2 years, didn't they create like 70 local laws? It was, there's local laws after local laws. I mean, you talk about like nitpicking, they were nitpicking and changing things left and right. And I'm not against that, but I'm just saying, we possibly would, change 2 things compared to 70. And this is the reaction that now, not before when they changed 70 things, but now
I don't think it was
changing 1 or 2.
It was 74, actually.
I just think you gotta look into it more and.
Well, that's why we're having a public hearing, to hear everybody's comments and we.
Nobody knew about this public hearing, Mike.
What's that?
Nobody knew about this public hearing.
Ms. Tanner, I respectfully disagree.
Yeah,
I think
1% of the town?
It's posted how every public hearing is posted.
No, it's not. I'm not saying anything against her, but there's older people, they don't have computers. They don't know how to use a computer, a phone. The Village of Ravena has a beautiful sign that could have been put up there. You can rent those signs to put it up. If this was such an important meeting, it should have been notified and people should have been notified about it.
Okay.
Okay?
So to circle back to your original question, the town was exposed 2 years ago when GE Verona was coming in. That's why we're saying that. There was going to be an industrial expansion.
Okay,
That's what they were saying.
okay,
This was before I was in office.
okay.
So
Yeah.
yes, the exposure's there. The town is exposed. You can say that nothing has happened and no businesses have been threatened, but the town they were in talks to do this, and they still are. We still are. There's still the process of the substation that's gonna be put at the port. That still has to be discussed.
That would be good.
We still have to discuss that.
I have to go to
There are larger
Coxsackie.
things like you're talking about, but the town was vulnerable, and it's vulnerable right now.
I disagree.
He can disagree, and anyone can disagree. We all have our opinions, but what we're saying is this was happening. That's when, do you remember when there was a line so far out this door that people couldn't get in?
Yeah, that I
That's when
couldn't.
more than 1% of the town was here.
Yeah.
That was that. What we're talking about right
what
now,
happened?
this is the loophole we're talking about closing. And it's a discussion that we can have,
Well,
and we're
I just
having
don't
it.
think you're doing it right
I think
way.
it's a loophole that's being targeted toward one particular piece of property, and it's gonna be a detriment to other farmers
Right.
throughout the
Yeah.
district.
Right.
And I think the optics that this board is presenting, it's being targeted toward one particular property.
Yeah.
That's my problem with
That's
it.
been
and I
going
think
on.
That's why we should do the whole thing in one shot. To eliminate our exposure for the legal liability that's gonna rain down upon us at some point if we do it this way.
It sounds like you're worried about the loophole for the industrial people to use the ag loophole. Is that?
Sure, yes.
the main
Yep.
thing? And I get it. It is good to look at it. But I also think if the industrial companies that aren't ag, but they want to use that ag loophole, it's fraud. So that's their risk. So what I think, today in the mail, I got my thing, I don't know if they came from Candace's office, I think they came from the tax. I got all my ag exemption things for properties I hay. They're other people's property, but I get them an ag exemption. In order to get those people the ag exemption, I have to show them I have to give it to the town, my Schedule F from my taxes. So if an industrial company, if Carver does a Schedule F, he's a farmer, according to the law. He should be able to get the ag then. So then it wouldn't be a loophole. But if he fraudulently, I shouldn't use him for an example, but if somebody does it under fraud, then they're taking that risk, I mean, and maybe the town could just look at it that way. Hey, the town makes us do a schedule, provide our Schedule F to get people an ag exemption on their property if we're haying it, or farming it, or whatever. So why wouldn't they do that with an industrial person? And that settles it. That Schedule F is I believe it's a federal and state tax thing, but still, it's proof that they're ag.
And
If they don't have that, they wouldn't be able to use any ag exemptions.
And this is why we're having this discussion, so if we do consider how to precisely define transportation terminal versus agricultural terminal, so this is very helpful.
Yeah, and the Schedule F is a key way to, illegal way to define it. I mean, I'm no lawyer, believe me, but.
If I may. So the Vernova thing, I had a part of that. The majority of that project was happening on industrial land, right? It wasn't about this. It was about a little tail on my part that fell before this all went. It fell under that lowest use property access. But let me get off of that. Probably the best example I can give you why the zoning ordinance needs to be redone. There is 353 acres, used to be owned by the Powell family. It's now the Queens Creek Wildlife Management Area. Yes, Mike, you and I talked about that. That's owned by the state. The state also sells land. That property is zoned I3P, right? 350 acres, but it sits out there. If you're serious about this, that needs to be addressed. That should be CF, community facility, right? That's what it should be. So here we are tapping around the edges, looking to hit these single things. It's going to cost money to do this zoning ordinance. We have a similar problem in the Hamlet. It's very difficult for businesses to start there because the zoning is R2, single family or double family, actually. Spend the money. You're going to spend it in litigation, or you're going to spend it to do it properly. There's going to be some grumbling. There's going to be people with RA zones that are going to be unhappy. There are going to be people like me. Mr. Schmidt, you remember I came to get an interpretation of that use to the planning board following the rules, and it was agreed by the attorney at the time that said, that's the way the law reads. Correct. It was there for a reason. It wasn't a mistake. At least for 60 years, it wasn't a mistake. So I would encourage the board to do the right thing, which is instead of dinking around on the edges, bite the bullet, be prepared for heavy weather, and do the zoning ordinance the way it should have been done 10, 12 years ago. It was done, it was kind of slid through, and it got beaten in court badly. Don't do that again. Do it the right way. I'm a participant. I want to cooperate. I like where I live a lot. Thank you for a second chance.
I shouldn't have come to this meeting tonight. Mr. Tanike, I may need your help on this one. Mr. Donnelly, when you spoke about the Verona GE meeting and stuff, that was not a town meeting. That was a planning board meeting. And yes, I had people out the door for hours. That meeting went on forever. A little small piece of this came to that meeting. That entire project, DEC took over as lead agency. That was so beyond what this town and the board at the time, because there were so many moving parts to that. Now, the piece of property that you're talking about, I believe was going to be utilized as a landing zone for the propeller blades.
Correct. There would be no structure.
There was nothing was going to be touched on the property. And that was something that was going to be agreed upon, because the planning board, we don't want people coming in. And I think I speak candidly for everyone on my board. I have an amazing planning board. We do what is in the best interest of everyone in this town. Not just that section where this was going on. We think, how would this affect everybody, not just one piece? Now, when the trees were clear cut, did it tick people off? Absolutely. Was it upsetting? Absolutely. We as two boards, planning board, town board, we have to stop trying to control people and their property and their rights. Having government is not, you don't want government to get in your life to tell you what you can and can't do without limitations, and I respect that, which is why we have boards. So people can bring stuff to the board, but not to change stuff that's going on. And if you're gonna change stuff, do it as a whole. Please, don't just do this one piece. It is going to make it a nightmare for the planning board. And as the Collins said, if you put this into effect right now, their business would not exist. I couldn't imagine not having the Collins in my backyard. Like, their company, their business, their family. So we have to think about it. And one last thing I want to state. I will not say the company's name If you know the town and love the town like I do, you'll know who it is. We have a company that gets beat up month after month after month for their trucks. They sold their trucks. They took their business out from down by the port, a portion of it. They're not there anymore. I run the Christmas program in my school. I have almost 100 kids who need help and need support. This year, I had to fear that because that company is no longer here, their trucking part isn't here, and their business part is not there, I had to fear that I was going to lose 20 or 30 of my kids from getting extra support this Christmas. Thankfully, it's not the case. That was detrimental to my students and all of the other kids in my building. This is a community. Our businesses, we need our businesses. So if we have a business that wants to ask a landowner next to them, hey, can I use your land to lay down something? It's not permanent. It's not affecting them. Why not? So please think about residents, business owners, everybody, not just one small piece. And if we're going to do one small piece, let's do it all and do it the right way.
All right.
Any further comment on the public hearing?
Thank you, Mr. Donnelly. I'm Barbara Heinzen. I live on the boundary of Queens and New Baltimore. I don't like seeing the entire shoreline industrialized. And that's why I didn't agree with the way that Vernova policy was being done. I don't see that laying down enormous wind power blades, how that is an accessory use to a residential property, which is what it would have required. So I disagree that this was legitimate within the definition that you're describing, Ms. Grogan. I think it was definitely an industrial use, and I didn't like it, and I didn't want to see industry expanding along the river.
Ms. Heinzen,
So,
may I interrupt you really quickly? You realize that that was the former Powell and Minnick Brickyard?
Yes.
Where that laydown was? It's never been anything other than that for over 100 years, just to be clear.
That's fine, but it is that land, in the plans that I saw, was RA land, and you're using it for an industrial purpose, and that's why I opposed that proposal at the time. Leaving that aside, when I first came here in 2011, there was a big expansion into the industrial park, and there is a lot of discussion about how we need a comprehensive rezoning in the town. There was a very strong planning board at the time, and they said it's extremely difficult, and it had never happened. It has still not happened. I tend to agree with the lawyers and with Mr. Stott and Mr. Donnelly that this is a loophole, and it's allowing the expansion of industrial development into RA areas where it does not belong. I think an appropriate definition of transfer station for an agricultural area is required, and if I were involved in this, I'd welcome the input of farmers. How would you define it so that you have the protection that's needed for agricultural and residential areas, but you still can do the business you need to support agriculture, because I know agriculture doesn't pay. I see it everywhere I've worked, and I've worked in a lot of places around the world. So I think the board would benefit from what your advice would be. What is the definition that works, that limits industrial expansion where it doesn't belong, but does protect the businesses that you need to do in order to support your agricultural businesses? And the zoning, rewriting the zoning law is a very, very long and complicated process. If it had been possible, it would have happened in your time. It didn't. So that needs a longer consideration. I think this is a loophole that needs to be closed, and I'd welcome the input of farmers who know what would help them and help the town board achieve what it wants to achieve. I don't see why that should be impossible. So that's my comment, and I wish you the best of luck.
Thank you.
Good evening. Nick Laraway with Carver's. I wanted to start out with a few questions. Do we know approximately how much of the town's land is RA or defaulted to RA based on your zoning law?
2/3, I believe.
Two-thirds, maybe?
70 to 80%.
Sure.
All of the discussion tonight has been about Trips Land and the project that we were talking about. Everyone that has come up with their own issues out in the hollow and other property, it's not aimed at them, but they're being affected by what you guys are trying to do. And I personally feel that that's wrong. You call it a loophole. We followed the zoning. We applied for a project. We worked through the process, and we got to a point where we put it on hold. But none of that has been discussed. We haven't even been contacted by the town board or the planning board on it in over a year. So what is the purpose and where did this come from? So that's my next question, I guess.
Mr. Laraway, I think the purpose where it come from, I think we already talked about that. It came from the fact that it's a very seemingly industrial definition that is, it has to be because it's placed in 3 other areas, all industrial in the town code. And like, why has this come up? Because RA is RA, industrial is industrial. And you sort of know it's a loophole because when we had billion-dollar companies, GE Verona, Wholesome, and multi-million-dollar companies try to use this to acquire a parcel of Mr. Powell's land to, sort of make this 500,000 square foot industrial complex. I mean, it's in, the proof is in the pudding. I mean, you didn't use anything.
We want to debate the facts of that project.
This, Mr.
Laraway. So will it lead to industrial
Industrial
expansion, industrial creep? I would think so because it's already been tried once.
But it didn't. We use
But
the
why
industrial
didn't
zoning.
it? It's not. It didn't happen, Mr. Larry.
Can I
Because
speak or do you want to?
What's that?
Let me speak, please. We proposed a project where we were building industrial manufacturing within the industrial zone.
Yes.
And we were using a portion of Trips land that was mined to make bricks, to store them in a commercial manner. And that's the next point I want to bring up. You keep talking about farming and agriculture and industry. There is something in between that, and that is commercial uses. Many of the things that apply to the transportation terminal are commercial uses that are used by families that have been doing it for 40 plus years all over this town. We keep talking about industry and we talk about agriculture. There is something that is in between that is critical to the lifeblood of this town. And you guys are just ignoring it. You're saying industry, industry, industry. I looked at Google Earth this afternoon and found over a dozen farms and other ancillary businesses in the RA zone, nowhere near the east side of Queens, that are going to be affected by this. Are you guys planning on sending your zoning and your building department out to each of these people and telling them that you're taking their property rights away? You're going to make them non-conforming, but if they want to expand their commercial use on their farm, they're going to be told that they can't because they're a non-conforming use. Is that the intent of this law? To run commercial businesses out of this town? Because that's going to be the outcome. If they want to expand their business after you pass this law, they're going to have to get in compliance with the new zoning law before they can obtain a building permit, is my understanding. Is that correct, sir?
Just repeat the question, I was taking down the notes.
If that family wants to expand their business that is non-conforming after this law passes, they have to get in conformance with the law before they can get a building permit.
No, they could expand up to 50%.
Okay, so they can expand some, but if they want to take their business and grow it, and if they hand it down to their kids and they want to grow it more, they're limited to 50% as of the day the zoning was passed.
That's correct, and that's my understanding is that's essentially where they were prior to this change initially being adopted back in 2020, because at that point they were a pre-existing non-conforming use as well under the then code, which was adopted in accordance with the 2006 comp plan, and then you had a couple of updates after that.
So back to my question, is someone going to take an inventory of all the businesses that are affected other than Carver? Because clearly there's been a lot of talk about it and we're well aware of what is being done here. Are you going to make these people aware so that they can come and express their opinion as to the effects on their livelihoods?
Well, one, this is what the public hearing's for, to hear perspectives. Sure. And two, when we had a workshop before this meeting, maybe 2-3 weeks ago, we talked about that. That was a concern. And we had talked about, well, if this has changed, what about some of those families or future families that want to do such things? And we also talked about maybe having an additional law that pertains to specifically that. And that was, submitted later this afternoon, a draft of that. So of course, we're thinking of other people outside of, North Queens and the hamlet in that area. But again, remember, Mr. Laraway, I understand that Mr. Powell's land, it was just to lay the blades down, but you didn't have the acreage on industrial land unless you had his land to lay the blades down on. So when the shoe's on the other foot, and I would have to say this, we are a pretty geographically large town with a large area of RA. When the shoe's on the other foot, just because it's not next to your house or your home or affecting, how you live, you talk to the people of North Queens and the hamlet, and you say, well, hey, what's the big deal? The big deal is when it's next to you, or it's going to affect your quality of life. When you built a home, when you raised your kids, and you built that home or raised your kids and saying, hey, industrial's there, commercial's there, I expect, my zoning and my way of life to sort of stay the same regardless. And the town board, in some cases, need to maintain a way of life. And I don't think that this definition in the agricultural zone is protecting the people.
But Mr. Scott?
Yeah.
This, in reverse, what you guys want to do, does affect our way of life and what my kids will inherit and what they'll be able to do and so forth. So, yeah, you can say when it happens to you or next to you, but that's why we're here. This is directly going to affect our property, our business, what my kids will be able to do in 20, 30 years from now if they want to expand and grow. This could severely impact that.
So what's a good solution?
Well, that's what we're talking
A
about.
good solution is to look at the entire zoning law and map and do an overhaul of it. And we would love to participate in that process. We own property in the town of Queens that is not zoned. You look at the map, there's white parcels that Carver owns. The Berkshire Spur between CSX and the Berkshire Spur. It has no zoning. We requested numerous times to have that fixed and it's still not zoned. So it's defaulted to this. We're using it as a transportation terminal and we have been for 10 years, but is that even right? I don't know because it's just a blob on the map that is not defined.
It could be worse, Nick. The circle and the ramp that you can't get to by a car is zoned R1. So clearly, there's a problem.
But I don't think that spot zoning, whether it's doing this and having a few carve-outs for existing businesses, that's not the right answer. The right answer is to have the planning board roll their sleeves up and do something that is often asked in many towns all around here, put together an update, present it to the town board, work collaboratively with the members of the town, and then vote on it and roll it out if everyone's on board. But we're not doing that. You're 2 years later here saying something about a loophole on a project that directly affected you.
But you weren't complaining about the loophole when it was benefiting you.
I don't even, you call it a loophole. I do not call it a loophole.
I do call it a loophole.
We followed the law.
Our lawyer
As
calls it a
written.
loophole, our attorney.
It's a loophole, or is it the zoning law?
It is a definition in the zoning law applied in the RA zone that is entirely inconsistent with your comprehensive plan and the description of the RA zone and how it's supposed to be used under your code.
But it is the law.
Correct.
It's
and I think
offensive that
that's
you're
why
sitting
the
here
prior-
calling it a loophole. We followed the law when we applied for it. We have a pending application before the planning board that includes this project. Is it even legal for you guys to do that while we have a pending application? Is that not spot zoning in and of itself?
Spot zoning has a definition. This is in no way spot zoning.
Okay. I'm not a lawyer, so I'm asking the question. Other than that, we just feel that the process hasn't been followed correctly. Our understanding from our zoning and land rights attorney is that before you open this public hearing, this was supposed to be presented from the planning board to your board for review and consideration. And that hasn't happened. They weren't even aware of it. And we just think that many of the processes have not been followed correctly. And we just want that on the record.
That the process was followed exactly how it was followed in 2020.
So you say they did it wrong, but you're doing it wrong because they did it wrong before, in your opinion.
I mean, that just seems to be how, if it was done like this in 2020,
It
then
wasn't challenged, but I'm here challenging it. That is
Yes,
not
you
the
are.
process. You need to have the planning board recommend it to you before you can open a public hearing, and you did not do that correctly. At least that's the advice of our council. Is that the law, sir?
I do not think that that's the law. If your council has a particular provision in the code that they want us to take a look at, I'd be happy to take a look at it.
Certainly.
Generally, I mean, this is the board that adopts local laws, and they are not prevented from considering a local law because it hasn't been recommended by the planning board.
But specifically related to zoning, when you have a planning and zoning board.
I'm not aware of that being a requirement, but I'd be happy to take a look at it.
Thank you.
Which could also open us up to liability.
Appreciate it.
I'm gonna call Judge Judy.
Very good. Anyone else? Okay. We'll keep it open in case anybody else comes. It's very productive, I think. Public announcements. November 26th through November 28th is RCS school Thanksgiving recess, and November 27th and November 28th. Thanksgiving, the town offices will be closed. Board members, you all received the minutes from the town board workshop on the 16th, the town board meeting on the 23rd, and the budget public hearing on the 23rd.
Yep.
Yes.
I'd like to make a motion to accept this to the record.
I'll second.
All in favor?
Aye.
For old business, we have the planning board and zoning board of appeals. I just wanted to bring it to the board's attention. We had spoke about this last year about possibly separating those two and having a planning board and zoning board of appeals that could be of oversight as it was in our past. Just bringing that up to see if there's any interest still in that conversation.
I think there's pros and cons. I was talking to Mr. Schmidt about it. Just sort of spitball information. I think one of the cons of having the planning and zoning board together is you're forcing people to sort of wear two hats. They have to decide on something dealing with the planning board, and then the same session, they could have to decide something based on zoning. And I think it's hard to differentiate, between, those two different entities. So again, you're asking people to do two jobs, which really should only be done, by one person, and you should have two boards in that case. But also, are there issues with splitting them? Is how do you find people? Let's say you have two 5-person boards, right? I mean, it's hard to find people for anything, public service wise, and how do you find enough people to get men and women on those boards to run them adequately? So that would be a con. So, again, I see some pros of splitting them up. I see some cons of it. I don't know. I mean, I'm not positive. Maybe Mr. Schmidt has more, information since he was actually on them.
The things that it was gonna make it quicker for people.
More efficient.
Yeah, more efficient.
Quicker was making 2 meetings per month. That's what made it really exponentially quicker. Ms. Grogan, you have your hand up?
I did have my hand up. I feel like I'm at school. I really came to the wrong meeting tonight. Mike, you and I have spoken about this. You are the liaison and you and I have spoken about this. And I respect that you brought it up to me at some point in time. I didn't realize it was on the agenda. It hasn't been brought up to me in probably over a year, so I didn't realize it was going to be conversation. There are pros and cons. I respectfully would love for the board to speak to the planning board who's living it, because the number one thing it does, I don't know if I should be there, the number one thing it does is it expedites it for the applicant,
Right.
which is the people. It's not me, it's not you, it's them. It is hard to go back and forth on certain things, but you just have to remind yourself what role you're in. I just had that contentious case, which was all zoning. So you do, but please look at all of the pros, all of the cons. Speak to the current planning board that's there to ask them before a decision gets made. Please talk to those who are living it only because, from what I remember, and Steve, you can chime in on this one, a zoning board didn't meet. It wasn't really scheduled unless there was a need. It wasn't twice a month like the planning board. So if
Well-
something,
I mean, to just stop you there, so when I was the chair, when the boards were separated, so I served the town of Queens on before they were joined and after they were joined. We only had one meeting a month the whole time until 2020 when the boards were joined and we had 2 meetings a month. So again, with having them separated, you know, there is a different thought process that goes into play. When you're wearing your zoning board of appeals hat, you know, it's very different than wearing your planning board hat. We, as a town, from my experience, don't have a whole lot of zoning issues that come up. So there was a period of time when I was on the zoning board of appeals where I think we went 17 or 18 months without having a meeting. Why? Because we had no need for a zoning issue. Nobody had asked us for an interpretation. Nobody had asked us for a variance. Nobody had asked us anything that was zoning related. There was a lot of planning going on, and I think primarily that is still the case. There's a lot of planning that goes on, and you can attest to that. You know, this time you had to wear your zoning board hat,
oh, I see way more planning.
but you haven't done that
Correct,
solely
correct.
in a long time.
No.
So
I'm just asking all of you respectfully, if this is gonna continue on conversation, please speak to all the planning board members. I know these 2 boards are supposed to run, one should not micromanage the other, but it is good to speak to those who are actually living it, doing it, and maybe if we redo the whole zone, we don't have to worry that much of zoning.
yeah, I mean, honestly, I think if we're going to talk about this, separating the boards more, I think we should have a workshop and we should invite the Planning Zoning Board of Appeals members to that workshop and have you guys a part of that discussion.
You do it after January?
Regardless, you'll be here, so.
2 weeks. 2 weeks, Chris.
Thank you.
So if we do look at a comprehensive zoning plan, would it be better that they were separated?
Yeah, I mean, it's hard to say from a comprehensive plan mindset. Again, I served both ways, and I think both ways worked effectively. You just have to have the right people. If you're going to continue to have it joint, you have to have the right people there.
Well, the planning plays into the zoning board though, so.
Right, but there's no reason why you can't wear 2 different hats
Oh, no,
at the
I'm not
same
saying
meeting.
that. I'm just
You
saying,
just have to, you know, again, have the right people in place there. But, I mean, I don't know that from a comprehensive plan type thought, I don't know that necessarily matters, whether they're joint or not.
I'm pretty sure the Planning and Zoning Board would welcome a workshop where other members could discuss and talk about it, so.
And technically, by law, you don't need a planning board. The town board could technically act as the planning board. You do by law have to have a zoning board of appeals.
Can you just stop?
I'm just saying, by law, you don't need a planning board. You do need a zoning board of appeals by law, so.
Okay. Any further discussion on that? Any more input, insights? Hearing none, we'll go to new business. I just want to.
Hearing's still open, right?
It is.
So regarding the Planning and Zoning Board of Appeals involvement, it's section 165-15. Part A gives you all the right to change the zoning law or the map. Part B says advisory report by the Planning Board/Zoning Board of Appeals. Any such proposed change in the text or zoning district boundary shall be submitted to the Planning Board/Zoning Board of Appeals, which shall submit a advisory report in writing to the town board prior to the public hearing. So I think unfortunately it was a misstep and
You have that for us?
Has that ever been done?
it's the law.
I understand that, Mr. Laraway.
What was it? Can you, the 165, what was it?
15.
We're putting the cart before the horse again, as we do.
I didn't do anything wrong.
No, we are putting the cart before the horse again. No. I know.
Okay, so for new business, just for discussion.
Or, I mean, what's the
No, I
process
think
here?
you would, and I'll take a look at that tomorrow, but I think, as you've read it, they would wanna schedule another public hearing at some point if you wanna proceed, and then prior to that, send it to the planning board.
I think that
And
would
get
make
their
sense.
advisory report before you open the public hearing.
In writing.
Yeah, I mean, we would,
We can have that done before January 1st, right? Doubt it.
Any further discussion? Okay, moving on to new business, just to start thinking about the 250th celebration. There are going to be some tall ships coming. I just want to see if we can pull a committee together. I just want to put it out there for board members or residents, anybody that wants to be on a 250 celebration committee. I talked to Joe Bolke about it, our local historian, and we're interested in doing that and possibly attracting some of that to Queens, specifically our landing. Okay, on to resolutions.
My Councilman Ho telling offer the following resolution and move its adoption, whereas the last day to collect water rents was October 24th, 2025, and any rents unpaid are to be levied on the 2026 property taxes, and whereas the Albany County Director of Finance has requested verification of unpaid water rents from the town board, ensuring the correct amount to be placed on the tax warrant. Now therefore be it resolved that the total amount of uncollected water rents to be levied to the 2026 property tax warrant is $31,899.04, which is a base amount of $30,597.39, plus $1,301.65 in penalties.
I'll second that.
Discussion? All in favor?
Aye.
Resolution carries.
I, Councilmember Stott, offering the following resolution, moves adoption, whereas the last day to collect for sewer rents was October 24th, 2025, and any rents unpaid are to be levied on the 2026 property taxes, and whereas the Albany County Director of Finance has requested verification of unpaid sewer rents from the town board, ensured to correct amount to be placed on the tax warrant. Now therefore be it resolved, the total amount of uncollected sewer rents to be levied to the 2026 property tax warrant is $38,199.93, which is a base amount of $34,799.47, plus $3,400.46 in penalties.
Second discussion? Hearing none, all in favor?
Aye.
Motion carries. The Supervisor Darling offer the following resolution and move its adoption. Whereas the Chief Fiscal Officer of the Town of Queens prepared and submitted a tentative budget for the year 2026 on September 25th, 2025, and whereas the Town Board of the Town of Queens has solicited feedback on the 2026 budget from the Town of Queens department heads and has discussed the 2026 tentative budget with the department heads on September 3rd, 2025 and September 15th, 2025. Whereas the town board made changes to the 2026 tentative budget based on those discussions and prepared a submitted and preliminary budget on October 9th, 2025 to the town clerk. Whereas a public hearing on the preliminary budget was held on October 23rd, 2025 at 6 p.m. at Queens Town Hall, 18 Russell Ave, Ravena, New York, and all interested parties were heard. Now, therefore, be it resolved that the Town Board of the Town of Queens does hereby accept the preliminary 2026 budget as the adopted budget for the year 2026.
I'll second that.
Discussion?
A couple of things. So I don't agree that we're proceeding with bonding half of the purchase price of the new plow truck. I had suggested that we pay the entire amount in cash from fund balance. I don't agree that the town attorney budget line item remains at $80,000, when for the past 2 years, that line item has been overspent. I don't agree that we are paying $22,000 for the town website. There was a recommendation to increase line item A3510.4, dog control contractual, by $10,000 due to the work that the state is going to require us to do. I don't see that we considered that. And I don't see any increase in money for the sewer funds to complete any upgrades to the sewer system. The amounts remain the same.
I'd just also like to clarify for the record that my deputy is still, I'm assuming, not getting the $2 raise, so even though she had the clerical error in last year's employee rate. I've discussed it several times. No one's really answered the question, so I'm assuming you're just stating it's a clerical error. She's only getting the $1. She's not getting the $2 that she's afforded. So I just want to know that now, so I can state that to her, that she will not be getting the $2.
Yes, in the whereas clauses, we have discussed this in depth, and I also put out a email on November 3rd where none of these points were brought up to our office that you just made.
I brought my point up at several meetings, so I'm assuming we're just sticking with the $1, and I'll make sure she's aware of that.
Yes.
Absolutely. no
Business
problem.
office and payroll, I think, both had discussions with you about that.
No, they did not. They hung up the phone on my deputy. Yes, and every time I bring it to you, you don't actually address it. If someone had actually just corrected the clerical error, it would have been fine. But we keep just floating past it. I don't want an answer. I'm just upset that no one is taking accountability and being able to say, hey, we could have rectified that situation. You didn't. And now someone wasn't paid what the resolution stated they were going to be paid for an entire year. That's all.
Can that not be fixed?
It should have been fixed, but no one actually ever rectified the error. They just let it go.
Certainly, but if you have a resolution, I mean, now's as good as time as any to fix it for her.
Well, I would think so, but they would have to reconfigure their numbers. I don't know if they can do that quick enough.
But if you have a resolution promising this person money and then you're not honoring it, that's not knowing the facts, that doesn't seem very reasonable.
There is over $20,000 in floater funds in the supervisor's line, so I'm sure you could probably take it from there if you needed to.
And the conversation, like I said, was had.
Several times. Never answered.
There's never an email regarding that?
There was never an answer. It's been brought up at this board, on this camera, several times.
As part of this public hearing.
I will,
Correct, but there are several inter-office emails that went back and forth. There are emails.
No one has
We
ever
don't have
answered
them
the
here.
question and said, no, it's not going to happen. You don't answer the question, is what I'm
It
saying.
was answered while we went over the tentative budget and then the preliminary budget.
No,
I believe you
nobody said
asked
a
the
word.
question.
I did, and nobody said a word. It said, next page, and kept going. No one has said specifically that Cheryl will not be getting $2 an hour, Candace. No, you didn't. You said, and you kept going.
It's not my recollection, but
That is my recollection, and I'm sure it's hers
I will
too.
make sure, Ms. McHugh, tomorrow I reach out to payroll and see what her take on it is, and I will make sure we communicate and solve anything that we can figure out.
Well, we had several discussions
Well, why
about it.
couldn't we have solved it the first 4
There were
times?
emails back and forth. And if I can remember from memory that you had communicated with Cheryl, pointing out the error with Linda Ziegler, she had communicated back, do we need to have a resolution on this? And you said, well, we can still keep the $2 for Cheryl. This is in 2024, LOL. So she took it that you were aware of the clerical error. You were okay with it. You had made a joke about it in an email. That's the way the payroll office had defined it to me. That's how our office took it.
So basically, you're stating that I am unprofessional in my LOL, trying to keep it light, and therefore you're going to penalize my deputy. Okay, got it.
That's not what I'm saying.
Yes, you are.
I'm saying that
Leave
you
him
pointed
alone.
out the clerical error.
And you didn't
to
fix it.
payroll.
And nobody fixed it. Why couldn't you say,
She
I
asked
need
you
to
in the
fix the
email,
resolution?
do we need to fix this in the resolution?
Am
I
I
don't
the
know if
town
you had a
board?
phone call.
No, she hung up on her and said, you're getting paid the right amount,
Respond
click.
to how
All you had to do was say you were going to amend that resolution. We've said this several times, and no one has bothered to amend it or address it, and it just gets floated across. I just want it known that this is upsetting, and regardless if I put LOL, it's not my decision if you correct that. I am not the town board. I do not vote on resolutions. I do not correct those things. You do, and no one here did.
Why doesn't someone table a resolution to fix it right now? You could pass over this in 30 seconds.
Thank you, Mr. Laraway. What we'll do, though, is I will make sure I speak to Ms. Seigler tomorrow, and I'll, stop in, talk to her, see what's been going on, see what she has as far as her opinion, and I'll reach out to you and or Cheryl, and I'll make sure we can try to solve this tomorrow. Okay?
Any further discussion? Hearing none. All in favor?
Aye.
Opposed?
Nay.
Can I ask why nay? Because of those reasons?
Correct.
But, Mr. Schmidt, with all due respect, the email sent out saying, how do you feel about the budget? Is there any
I think my position has been very clear about the truck.
We've talked about those things.
And we certainly talked about it during our workshop and our meeting with the department heads.
Okay.
10 days ago, my secretary sent out this email. Are there any last minute changes to the budget? We want to start printing them out. Not from me, thanks. From Linda. I don't have any changes from Mike. 0 from Ron and Steve. So we
If we have
cannot
issues, we
work
gotta speak
without
up.
information. If you want to
I think my
contact our
position's been
office-
very clear.
No, it's been very ambiguous.
Yeah,
These
okay.
things that you don't come to us and communicate with us.
I'm
we're not
communicating with
mind
you right
readers.
now.
Right now.
I've communicated with you about the budget at the budget hearing,
Mhm.
at the public hearing, at our workshop, and everything else. So my position's very clear.
No, it's not. It's very ambiguous.
Okay.
We'll move on.
I'd like to take this moment to read the 2026 budget message that I wrote for our 2026 budget that just passed.
I thought we were doing,
I'm going to take this moment to read this thing. Before I speak about the budget, I would like to take a moment to recognize the people who make town government work every day, our department heads, our employees, and town board members. Their professionalism, dedication, and teamwork have been essential to every success we've had, from the offices to the highway, from law enforcement to public works. Each person plays a vital role in serving our residents and keeping Weemans running smoothly. I'm grateful for their steady commitment to excellence and their shared belief in what we're building together. Moreover, I would like to express my sincere appreciation to our business office manager, whose professionalism, attention to detail, and dedication are essential to the town's financial operations, and to our accountant, whose years of service and deep knowledge of Queens' fiscal history have been invaluable in maintaining our strong financial footing. Their efforts and collaboration are a cornerstone of our continued success and financial stability. The 2026 adopted budget represents the continued progress of our administration's commitment to fiscal responsibility, transparency, and long-term community investment. This budget builds upon the strong financial foundation we have established over the past 2 years. This foundation is rooted in strategic planning, smart investments, and responsible management of public resources. Over the past term, we have centralized local government operations, strengthened intermunicipal cooperation, modernized services, and invested in the infrastructure that supports residents, businesses, and future growth. Through the proper management of our town's fund balance and our participation in night class, the town now earns more than $20,000 per month in interest. These revenues directly reduce the burden on taxpayers and allow us to reinvest in local priorities without raising taxes. The town of Queens stands today in one of its strongest financial positions in its history. This is the direct result of planning, teamwork, and sound fiscal management, not chance. As we look ahead to 2026, this budget is not merely a financial document, it is a roadmap for continued growth and accountability. As strong as this budget is and as much as it provides, it is vital to remember that numbers on paper are not the heart of a community. People are. And what matters most is how we use these resources to protect our most vulnerable, to safeguard our democracy, and to foster pride in our community and in ourselves. A balanced budget is important, but more important is what you do with it. Strong fiscal policy means nothing without vision, and there must be a purpose that drives every dollar towards improving lives, strengthening neighborhoods, and inspiring civic pride. This budget reflects not just balance, but a clear path forward for Queens built on responsibility, compassion, and shared purpose. Together, we are proving that good governance, responsible spending, and long-term vision is delivering results for the people of Queens.
How much did you pay for late charges, for paying bills late?
0 in the past 2 years.
No, that's not true.
It is true, Barb. It is true. Well, I know so, because I work in the office. So thank you.
Good.
Steve, you want to take this one, or you want to pass it along?
I, Councilmember Schmidt, offer the following resolution and move its adoption. Whereas the Chief Fiscal Officer of the Town of Queens has determined that in order to maintain proper balances within various accounts, an inter-fund transfer is necessary. Now, therefore, be it resolved that the Town Board of the Town of Queens does hereby authorize Supervisor Stephen Donnelly to transfer the funds as depicted below for the budget year 2025. General Fund A, amount $6,500 from A 1990.4 contingency to A 8090.4 environmental control leachate contractual. I'm not sure where the environmental control part of it came from, because my review of the budget just indicates that it's leachate facility contractual, but in any event, $20,000 from A 1990.4 contingency to A 1420.4 attorney contractual. $5,000 from A 1990.4 contingency to A 1355.4 assessor contractual. $4,000 from A 1990.4 contingency to A 1220.4 supervisor contractual. $450 from A 1990.4 contingency to A 7240.4 band concert contractual.
Second that.
Seconded by Ms. Bruno. Discussion?
So I have a couple of things that I'd like to just chat about. I reached out to our business office manager this afternoon to find out some information. So currently, the contingency balance prior to today and the transfer of this money is $97,504.06. 8090.4, which is leachate facility contractual, in 2025 was budgeted at $10,000. The current amount is negative $5,721.72. 1420.4 attorney contractual in 2025 was budgeted at $80,000. The current amount is negative $1,076.85. 1355.4 assessor contractual, the 2025 budget amount was $18,552. The current balance is negative $4,308.34. 1220.4 supervisor contractual, the 2025 budget was $900. The current balance is negative $7,909.70. 7240.4 band concerts contractual, the 2025 budget is $7,650. The current balance is negative $450. After these transfers, the remaining contingency balance will be $61,000 and change. We are transferring a total of $35,950 from contingency to various accounts. And as you can see, the reason for that is because we are negative in all of those accounts listed, which are 5 of them.
So to clarify, contingency is for end of the year cross leveling. There is the accounts that are overdrawn are because they were budgeted at a certain amount, and then things come up throughout the year. So for the environmental control at leachate, the pumps and the bills, you can remember the pumps that Keith was here and said we had to order. So that came up unknown. This is what contingency is for. It's for cross leveling at the end of the year. $20,000 for the attorney contractual. You met with Mr. Goldman. He's not free. He came down.
We don't have his bills yet.
Yeah, I know.
confirmed with
That's
that.
why we're putting it in there so we can.
Well, that's not
pay
true,
those.
because we're negative $1,076.85 right now, And Mr. Riley is still going to submit a bill for November, and he's
And
also going to
December.
bill for December.
That's why we're putting $20,000.
So Mr. Goldman, as of right now, as of this conversation right now, has no bearing in the fact that we're already negative $1,076.85 in attorney contractual.
So overdrawn is not negative.
It's not?
You're sort of framing it as if there's a negative balance in a bank account somewhere, which there is not. This is probably why some residents are not understanding how this works. So we're explaining it clearly to them. So this comes from the 2025 budget, where we budget out an amount, and when you go over, when you spend money, you have to use contingency. That's what contingency is for. There's $120,000 at the beginning of every year, going back a few years, specifically for this purpose. In each one of these, we're just meant to cover, and that the band concert was if you remember, some of the bands were canceled because of weather. The band had to get paid, and it was not in the band of the 70.4, so that had to go over.
But Steve, doesn't somebody keep track of these things? You know, like at home, if I've got
Business account
$5,000.
manager, the accountant, and the business office manager.
But all of these are
This is all
minuses.
very normal. This happens every single year. If you go back and look through resolutions, year after year after year, you always cross level.
I mean, you're talking $7,000 in some and $4,000 in others. That's a lot.
Right. So this is a non-issue, but we're having a conversation about it in order to clarify it for the residents, because you should know how a budget works. And I want everybody to know that all the budgets, going back to 2015, 2014, all the annual financial reports are on the town websites. If you want to dig into them, I encourage you to. It's very important to know how this stuff works. And if you have questions, and I've been saying this for 2 years, please come to the supervisor's office. You can come in person. I saw you the other day go to the assessor's office, and I thought you were going to come in to say hi. I wish you would have. I love when people stop in. If you have questions, going through our budgets throughout the years, you'll see numbers wildly fluctuate and wonder why, because I used to do the same thing when I was, I guess a civilian or a resident that didn't know how the budget worked. Why did this go from 30,000 to 60,000? Why did this go from 60 to 0? You don't get answers when there's nobody in the office. I'm in the office. Come in and ask me, and I'll answer them for you. That's a promise.
A perfect example is, I don't budget for an attorney, but when I need one, I get the money from somewhere, right?
We have contingency. We have $120,000 contingency so we can level up the books as the year goes on.
It's an estimate though, right?
Sure. But again, these numbers should be reconciled prior to them being in the negative.
Did you have a conversation with Regina about this? And what was her response?
She just gave me the numbers.
But you didn't ask, like,
So-
is this normal? Is this?
When she goes through the numbers and she sees that there needs to be this is exactly, you're describing exactly what's happening.
That's what a
I
contingency
was just
budget is.
providing the public and the board with information that
Thank
I
you.
got this afternoon.
It's important to
Period.
do that.
And I've had these same questions every so often, Mr. Schmidt, and I always either call or stop in and see Regina and say, can you explain this to me? And usually it's, what you see is not necessarily like, oh, we're negative here, we're negative there. It's how you cross-level a budget as you go throughout the year. And I would expect Regina too. She's great at her
We budget
job.
very differently, I guess, because I don't budget like that. But
I'll go visit Regina tomorrow, and we'll give you a call.
You budget
We'll
out
be
the
on
fuel
speaker.
for your car throughout the year, and then all of a sudden something happens. An engine blows. I mean, it happens to us all. The washing machine breaks. We didn't budget for that. Uh-oh. We all live paycheck to paycheck. Well, I guess not all of us do, but we all live paycheck to paycheck. And it's a well-known fact that a $400 bill can push people into using credit cards, and how are we going to make it through? You budget the best you can, which is amazing. Our business office manager is great, and so is our accountant. We talk to him all the time, and I'm so glad you called her and talked to her, because it's important to do that. Any further discussion? Hearing none, all in favor?
Aye.
Opposed? Motion carries.
I, Councilmember Bruno, offer the following resolution and move its adoption. Whereas the chief fiscal officer of the town of Queens has determined that in order to maintain proper balances within various amounts, an amendment to the 2025 budget is necessary. Now therefore be it resolved that the town board of the town of Queens does hereby authorize Supervisor Stephen to amend the 2025 budget as depicted below for the budget year 2025. Increase appropriations, SS 8120.4 sewage collection system container, $60,000. SS 9050.8 unemployment, $6,048. SS 9040.8 workers' comp, $2,261.75. Increase appropriated fund balance, SS 0599 fund balance, $68,309.75.
Discussion?
So again, I'll just reiterate what my discussion with Regina was this afternoon. And again, this is just so that I'm providing the information based upon how it was explained to me. SS 8120.4 collection systems contractual, the 2025 budget was $50,000. The current balance is negative $53,103.45. The current fund balance that we have for SS is $423,515.93, which is a good thing. SS 9050.8 unemployment insurance, 2025 budget was $0. And now we're looking to transfer $6,048. And SS 9040.8 workers' compensation, the 2025 budget was $7,000. And we're now transferring $2,261.75.
Okay, so 8120.4, our accountant had to recode those bills so that the village could be apprised of them. I think 53,000 of those dollars they need to look at. We have to have that discussion with them. You know that we have a negotiation coming up.
Correct.
That's what that's for. The $6,000 unemployment, it was $0 before, but if you'll remember, we had a resignation, or Mr. Pretori. So his unemployment he had put in is $6,048. So that needs to get paid, so that's why that's there. And the same with workers.
So again, for 2026, did we, put some money in these other funds where we have been overdrawn to ensure that going forward, we don't run into a situation where we are negative $53,103.45.
We typically went how we're trending, and we're still doing that. Like you said, we couldn't predict that Mr. Pretori would leave the position.
I get that.
Unemployment, and the same with the village. We have to have that discussion with them. So the money has to be transferred in order for the budget to be balanced. And as far as what the future may bring, we deal with that as it comes. That's what we're doing right now. So yeah, the money has been budgeted to the wastewater treatment plant in the SS fund. Oh, any further discussion? Hearing none, all in favor?
Aye.
Aye.
Motion carries.
Councilmember Hoteling offer the following resolution and move its adoption. Whereas the board of the town of Queens recently purchased real property located at 2524 US Route 9W, Ravena, New York, the property, to allow for the relocation of town hall offices to a suitable location that provides adequate space and public access to the project. Whereas the board, by resolution 127-25, accepted a bid to complete renovations related to the project from AOW Construction LLC in the amount of $205,668, the capital project cost. And whereas it has been determined that additional information technology work will benefit the town and make individual offices more functional, and whereas to complete the additional information technology data work, AOW Construction LLC and its subcontractors have indicated that a change order is necessary. And whereas the town has received the proposed change order from AOW Construction LLC in the amount of $20,437.80 to reflect the cost of additional installations, such change order being attached hereto and made part hereof. And whereas the town, having originally transferred $250,000 to the 9W Renovation Capital Fund, has sufficient funds in the capital fund to cover the change order in its entirety. Now therefore be it resolved that the town board of the town of Queens hereby accepts the attached change order received from AOW Construction LLC in the amount of $20,237.80. The town board of the town of Cleveland hereby authorizes such change order to be paid for using funds from the established H50 9W Capital Renovation Capital Fund. And the town board of the town of Cleveland hereby authorizes Supervisor Stephen Donnelly to sign the change order on behalf of the town and to take such further actions as may be necessary in the acceptance of the change order.
I'll second that.
Discussion?
So a couple of questions. Why is this additional information technology work just being contemplated now?
Couple of reasons, sort of a perfect storm. So Edmunds reported to us that they weren't going to be doing IT work anymore, so we were out looking for other IT companies, and very recently they came back and said, oh, guess what, we are gonna do IT. So instead of enlisting another IT firm, obviously we use them because we use all their software, MCSJ, for example. So that was one part of it. The other part of it is the doctor's office had some ports, but not enough for a municipal office. So we had to add some to, and sometimes two in each office. And the third point is some of the department heads changed their furniture plan a bit from the original plan. So say if somebody moved their desk, it was planned to be here under an original port and they wanted to put it here, well, they're gonna need a port for their computer and their printer. So that kind of took us all by surprise, but the price definitely took me by surprise. I thought it was gonna be at the most 10, but it came out to be 20.
So that brings me to my next question. Why wasn't this work originally placed in the scope of work document produced by LaBerge Engineering Company? Like, because if this was in the scope of work document, when the contractors bid on this, they would have known we wouldn't have needed a change order, and we wouldn't be out here looking to pay an additional $20,237.80.
Correct. So, for an example, the assessor's office had the desks all lined up near the ports that existed. They changed the plan to how they want their desks to be, and ports needed to be added. Same thing. I think and when we went through offices, I think printers may not have been taken into account for, because at the same time, in the mailroom, we wanted to have a single printer, but it's a situation where this is new, and the project's new, and us coming all back together is new, so we're going to have to live in that building for a while and see what people need. So we really want to have everything there while the ceiling is down, while the walls are up and painted now. We're at the final stages where they're running wire. And this data wire is essential to a large municipal office with 7 departments in it.
Yeah, I would have thought that this would have been considered prior, and when the scope of work was being thought about and produced. I mean, LaBerge was down to that office. They should have known what kind of information technology supplies were already there. And if they thought that it needed to be upgraded, then that was the time to put that in their scope of work.
Yeah, and Jim will say that to you, and he's said it multiple times. Once you start tearing down walls, you're not sure what you're going to find. So as far as change orders are concerned, this is our first one. We had a couple of other CORs that come into effect, into play as they, and some actually dropped off. We had a few $1,000s of CORs drop off that we didn't need on the project. So it's basically a tenant renovation, and it fluctuates at points, and this is one of those points. Further discussion? All in favor?
Aye.
Opposed? Carries. Does everybody have the B fund? You have it?
That's right.
Yeah. I just want to make sure everybody has it in their packet.
You have it on there? You give this?
What?
Mm-hmm.
This one?
Yes.
I have that one.
Okay.
Appropriations?
Yep.
All right.
I, Councilmember Stott, offering the following resolution and moves adoption, whereas the Chief Fiscal Officer of the Town of Queens has determined that in order to maintain proper balances within various accounts, an amendment to the 2025 budget is necessary. Now therefore be it resolved that the Town Board of the Town of Queens does hereby authorize Supervisor Stephen Donnelly to amend the 2025 budget as depicted below. For the budget year 2025, increased appropriations B 9060.8, health and medical insurance, $1,895.15. And then increase appropriations fund balance, B0599 fund balance, $1,895.15.
Second, discussion?
So again, B 9060.8 health insurance was, in 2025, it was budgeted at $51,800. And the current balance as of this afternoon was negative $1,895.15.
Premiums went up.
Well, that may be, but we're still negative. And this wasn't discussed prior to it
it's
being
still-
negative.
Okay. It's still a mischaracterization that you keep saying that, so you might want to modify your language. Premiums went up, unbeknownst to us in the 2025 budget. We have since, in the 2026 budget, without much information from the insurance companies, already baked in 10% of an increase for this year.
That's good.
Yes,
That's what should happen.
that's what did happen. Ready for the discussion? Hearing none, all in favor?
Aye.
Aye.
I Supervisor Donnelly offered the following resolution and move its adoption. Whereas column 18 of attachment 5, schedule of district zoning regulations to chapter 165 zoning code of the town of Queens contains historical language suggested that site plan review by the Planning Board, Zoning Board of Appeals is not required for principal uses in the town's industrial I-1 and I-2 zoning districts. And whereas the principal uses in the town's industrial zoning districts include major industrial uses that can have significant impacts on nearby properties in the community as a whole, such as quarrying and extraction operations, manufacturing, assembling and processing facilities, wholesaling with storage, transportation terminals, building material plants, and trucking terminals. And whereas the local law number 1 for 2011, the site plan review law, the town enacted chapter 136 to the town code, providing the site plan review of certain projects. And whereas the purpose of the town site plan review law was to A, achieve efficient use of land, B, protect natural, archaeological, and historic resources, C, provide a consistent and uniform method of review of certain proposed uses and development plans, D, ascertain that any significant redevelopment complies with current standards, E, review adverse impact on adjoining or nearby properties, F, retain rural and natural resources with a clean and attractive environment as well as continued development of the economy of the town and the general welfare of its inhabitants, G, conform to the comprehensive plan and zoning requirements as amended of the town of Queens, H, create an accurate record of approved development, whereas in addition to all other applicable laws, the site plan review law requires that the town board, ZBA, shall consider the following when reviewing a site plan review application. A, traffic patterns, ingress and egress. B, pedestrian safety and access. C, parking and loading areas. D, screening and landscaping. E, environmental air quality. F, fire protection equipment. G, draining stormwater runoff. H, refuse disposal. I, location and placement of signs. J, location and dimension of buildings. K, impact of the proposed use on adjacent land uses. L, snow removal. M, location design and all construction materials of all utilities, energy, and communication distribution facilities, including gas, solar, wind energy, telephone, cable, water, and sewer. N, impact of the proposed use on both on-site and off-site infrastructure. O, effects of smoke, noise, glare, vibration, odors, and or other noxious and offensive conditions, if any. P, effects on historical properties listed on the national, state, or historical registers, if any. Q, effects of other cultural, archaeological, and historical resources of the town, if any. Site plan review, section 136-6, whereas the site plan review is expressly required for the construction of any new structures, development of any new uses in all other buildings or development activities. See site plan review section 136-4A. And whereas site plan review is also required for the expansion of any existing use, with expansion including but not limited to a floor space increase of 25% or more within any 1 year period, or the introduction of new materials or processes not previously associated with existing use. See site plan review law, section 136-4B. And whereas site plan review law contains an express repealer provision, making clear that in the event of any provision of any other Town of Queens local law, ordinance, or regulation was in conflict with the site plan review law, those provisions will repeal. See site plan review law, section 136-14. Now, therefore, be it resolved, the town board of the Town of Queens directs to avoid confusion concerning the town's zoning code and site plan review law, a clean version of Schedule F to the zoning code be prepared that is consistent with section 136-14 of the site plan review law. 2, the board further directs the town building inspector, who is charged with the general and executive administration of the zoning code, see zoning code section 135-12A, to work with the town attorney and or the planning board ZBA attorney to determine if any projects requiring site plan review since 2011 have not received necessary approvals from the planning board, zoning board of appeals. 3, upon a determination that a project requiring site plan review has not received necessary approvals from the planning board, zoning board of appeals, the town board encourages the building inspectors to refer the project to the planning board, zoning board of appeals for same. 4, in the event the site plan review law is not complied with in connection with a particular project, the town board directs the appropriate town officials to notify the town board of same so that it can make any necessary actions to protect the health, safety, and welfare of the town.
I'll second that.
Discussion? Do you know anything about this?
No, I'd like a copy of that.
As would we.
So does this fall under the same thing where, you guys should know about this before we talk about this type of thing?
Where did this originate from?
Don't know.
Mr. Riley, you've done some research on this. Do you want to just help us explain exactly the process of how we got here?
Sure. This originated from conversations that I had with the code enforcement officer, where he expressed questions or uncertainty about his ability to call for site plan review in the context of principal uses in the industrial zone, which, as you know, are some of the most intensive uses in the community. Based on those discussions, I did some review of the history of that language in the code, as well as the site plan review language in the site plan review law that was adopted in 2011. I've reviewed both that law as well as the minutes associated with the adoption of that law, and it was pretty clear that the purpose of the law and the discussion at the time was that it would in fact allow for site plan review of those principal uses in the industrial zone. It contained a repealer clause, but for whatever reason, the schedule itself didn't actually get cleaned up, which caused some confusion. And so this is an attempt to work with Jason, and I spoke with Mr. Kinnery today to try and identify, are there uses that should have come in for site plan review that have not?
But you're changing the law as currently written and presented to the public.
Yep.
That resolution says negotiate a clean version to be prepared or something to that effect, correct?
Yeah, I mean, as a matter of law, that happened back in 2011.
But you can't change the law by resolution.
They did it back in 2011, and
But you can't change the law by resolution.
yeah, I would take the position that we're not actually changing the law, that happened back in 2011.
But the law as written will change. You are changing the law by resolution.
Yeah. I disagree with that characterization.
I agree with the characterization. I'm
So-
not a lawyer, but you're changing the law. This resolution changes the law.
Do you have an extra copy right now on hand?
Two, please.
Just, I mean, as the chairwoman of the
So-
planning board.
So I have, so this,
I got it on my phone. I can look
this
at it.
being a town board discussion, I have some issues with regards to how the resolution is written. It says, the town board of the town of Queens directs that to avoid confusion concerning the town's zoning code and site plan review law, a clean version of the Schedule F to the zoning code be prepared that is consistent with section 136.14 of the site plan review law. I have dealt with this schedule of zoning regulation since I've been on the Zoning Board of Appeals starting in 2011. And it has been clear that in the I-1 and I-2, when you look at this schedule of district zoning regulations, it says required site plan review and approval by planning board, zoning board of appeals for I-1 for all except principal uses. So you go back to the first box, which has all the principal uses, and to me, it's pretty clear. For all except principal uses. In the I-2, the same thing. When you look in the last column, it says for all except principal uses. You go back to the first column, you look at the principal uses. So I'm not really sure why the wording is avoid confusion. It's pretty clear to me. The other issues that I have with this resolution is the town board further directs the town's building inspector,
Go after everybody from 2011.
who is charged with the general and executive administration of the zoning code, see zoning code section 135-12 subsection A, to work with the town attorney and our planning board ZBA attorney to determine if any projects requiring site plan review since 2011 have not received necessary approvals from the planning board/ZBA. It further says, upon a determination that a project requiring site plan review has not received necessary approvals from the planning board/ZBA, the town board encourages the building inspector to refer the project to the planning board ZBA for the same. Now, if I was an applicant in 2011 or from 2011 until 2025, and I was working off of the zoning code and I was in full compliance with the zoning code, I don't think that this board should be able to make those people come back before the Planning Zoning Board of Appeals for a site plan review. Their application, when it was approved, was specific about this law and this schedule.
I would also, say again, so people who don't know what he's referring to, you look at the Queens Code, the schedule of districts and zoning, and you look at, for example, you go through the zones, like RA, residential agricultural, and it says required site plan review, and it says for all special permits. Then you go to, you go down to B1, general business. For all uses, you need a site plan review. You go, again, to like R1, R2, R3, R4, and it says for all special use permits, for all uses. And then you get to planned commercial, and it says for all uses, you need a site plan review. And then you go to industrial. As soon as you get to industrial, it's, and again, industrial, the primary uses are things like a manufacturing, assembly, and processing facility, research and development laboratories, wholesaling with storage, barge and ship terminals, transportation terminals, building, material plants, farming and timber operations, trucking terminal, fuel storage terminal. So these are the principal uses, but for the section where it says site plan review required, it says for all except principal uses. And then the same thing, yes. Come on, I'm not done. The same thing says, for I2 industrial, for all except principal uses. So if you want to open a coffee shop on Main Street, you have a site plan review. But if you want to open an industrial site, you don't need, you're exempt, except for, to me, how is that?
So fine, hold on, Mr. Laraway. So fine.
Educate me, yes.
So fine, if you want to take that position and you want to change the zoning code and you want to make it so that for all uses, a site plan is required in the industrial zones,
Yes.
fine, we can consider that. But I am not willing to consider the fact that you now, or we as the board, has the power to go back to the building code enforcer or the building code inspector and have him start going through applications from 2011 to 2025 and say, okay, well, this was in the industrial zone and they never had site plan review, so therefore they have to now come back for site plan review.
And if we don't like it, we're gonna.
That's ridiculous. They followed the law, they followed the code that was in effect when they filed their application. So again, if you want to change, we can have that discussion. But to open this can of worms up and to allow the building code inspector to then figure out whether he wants to bring these people back in when they were approved based upon the code? No.
Not to mention what havoc it's gonna wreak on our planning and zoning board, you know, down the road.
How long has this been on the table? When did you guys see this?
We talked about site plan review.
8 weeks ago, maybe?
How long has this
When
been?
I got this resolution, I got it yesterday at 2:30 in the afternoon.
And you're gonna vote
Oh,
on
no,
the
I mean,
resolution
we
this time.
circulated it.
We talked about site plan. I have not seen a
I don't
resolution.
want to get in the weeds, but I mean, the draft of the resolution has been out there for.
I think the
Really?
draft of the resolution
We
made
talked
it
about it.
prior to.
We talked about it. I did not see a resolution until 2:30 yesterday afternoon.
Maybe around 4:30 before, yeah, but.
But there, just to be clear, there are numerous other things within your zoning law that require industrial uses to go for a site plan. If we subdivide our property, we have to come for a site plan. And that includes reviewing the building, the fire sprinklers, the stormwater, everything you've done. Our stormwater permit requires us to follow those same laws. But to now say by resolution, if 3 or more of you vote for it, that you're going to go back to 2011 and change the law because you think maybe somebody made a mistake. You are now looking back 15 years and interpreting what the people sitting before you 15 years ago wrote on a piece of paper and no one has questioned or even discussed until 8 weeks ago.
That's a very good point. Why from 2011 to now, what happened in that time that no one enforced this though? Code enforcement?
That document says that it's not required.
Never had to, there was no site plan. I'm just thinking of the sewer of Riverview, because when I asked our chief operator, where is this all coming from? And what is it? He goes, I have no idea where this water comes from because
Sewer?
the wastewater going into Riverview.
The sanitary sewer from the industrial park?
Yeah, that goes into Riverview.
I'm gonna step in here as an old man.
Thank you.
The stormwater on Riverview has been shooting out into the Queens Creek since I was a boy. It goes in unfiltered. Every town board has had the opportunity to do something about, and every town board has looked the other way. I'll be frank with you. You have got people in this town who are desperate to get trucks off their road. You have 2 companies that you're dealing with market capitalization over $60 billion. Don't you think it would be a wise thing to do to take care of those people who are scared of their children getting run over instead of, frankly, dicking around with this?
This is actually meant to.
So back to the sanitary
This is
sewer.
actually meant to get those trucks off the road. I was speaking with Heidelberg and Amrise today at the quarry. I didn't see you there. So we are working on this, and we've been working on it for 2 years.
There.
Were you there? Okay, well, I still recognize you.
You guys this under some feigned mistake that maybe somebody made 15 years ago, but you just said it. You're doing this to try and take trucks off the road. That resolution
We're trying
doesn't
to protect the town, of course, yeah.
I don't
There's
understand.
no site plan review for tens of thousands of trucks.
What do you mean there's no
annually.
site plan
No,
review? That
there's
sanitary
no site
sewer
plan.
that you just brought up, that was reviewed as part of the subdivision application for the Queens Industrial Park. It was reviewed and approved by Albany County Department of Health before we installed it. It was dedicated to your village or your town sewer department. All of those things happened. We followed the rules. We built it correctly, and we followed the rules as the town had laid them out. To go back and say that 15 years of our work is going to be reviewed, and many other people's, are you going to have Lafarge tear their plant down? That was built since 2011. So is your code enforcement officer going to crawl through their plant and you're going to shut down their enterprise because you're trying to take trucks off the road?
Well, if it was built correctly, what would be the issue with our code enforcement
But you're going to make them spend hundreds of thousands, if not millions of dollars going through a retroactive site plan process? That can't be legal.
You guys are
None
gonna
of this
push
is
them out.
legal.
They're gonna leave. They're gonna leave our community, and things like Trish just said, she relies on donations from these big companies for our children in this community.
They're not going anywhere.
There's, are you joking?
Yeah.
Harper
Oh
already
my
took
God.
some of
Didn't
his
somebody
business
already
somewhere
leave?
else.
They're not going anywhere.
I thought somebody already left.
They pay for free Thanksgiving dinners that are getting passed out at Shop and Save. They pay for children that need help for Christmas. Like,
So you guys know
fighting
better
them.
than the last 15 years. You guys know better. You want.
We know better to have conversations, and that's what we're doing right
The
now.
conversation, you're tabling a resolution.
Resolution on the table. I mean, technically, the public doesn't even get a say right now. This is a public hearing. This is the
public hearing.
Because it never got closed.
Sorry?
The public hearing never got closed, so it's still a public hearing.
No, I know, but this is solely for the resolution, Mr. Collins, yeah.
But the facts.
And you know me, I'll let anybody
The
talk.
correct facts, because you were not even living in this state when the time that sewer main was built.
It's great that you're bringing this up because then.
Sure,
we
so
can
ask
go
the
to-
question before you put a resolution before us to try and shut our business down. That's what you're doing.
It's because Mr. Stott is a code guru now, because notice every question gets answered by Mr. Stott. So he's directing the town attorney to look into all these code and zoning laws. That's what's going on. Let's call a spade a spade.
And that's not
I
a
never-
conversation when you
Ms.
put a
Collins, I never
resolution up to
mentioned,
vote
okay.
And have a discussion. That's not a conversation. You were gonna vote on it 2 seconds until Nick got up. That's not conversation. This is an abuse of power. Direct abuse of power that you
This
guys
is a
have the right
conversation.
to go back
It's not
15
a
years
it's a
and
vote.
say this was done wrong. You're gonna come back to us now.
So let me just
That
ask
is
a question of
absolutely
your
wrong.
attorney.
Mike,
Absolutely wrong.
All of the people, if you pass this resolution and you sick your code
That's a
enforcement
compliment
officer
to you.
on trying to
Really
shut down
is.
enterprise, does not every one of those businesses have the right to claim detrimental reliance because they followed the law and you now changed it on them and tried to retroactively change their business?
I would submit that they did not follow the law because they did not follow the site plan review.
But
I
the
would
law
also-
says.
If you could also- if you could just let me
How did
continue.
it get?
Absolutely.
Chapter 136 is
I
here.
would also note that when this was enacted in 2011, there were repeated public meetings at which representatives of Carver companies opposed the local law because it was going to make them, as an industrial use, go through site plan review. I mean, that's reflected in the minutes.
But we followed the process as it was given to us by code enforcement since then. The town board, the planning board, we have been part of probably 30+ site plan reviews over the last 15 years that were enacted because of other uses, because of subdivisions, because of changes. But to now say that you are opening up everyone in this town, in the industrial zone, to scrutiny over the last 15 years because you think maybe somebody did this by passing a resolution to change the law? Like, there's just so many holes in what you're doing right here. I would suggest that you reconsider, and if this is the position you want to take, you do it the right way.
I'm flabbergasted at this. Mike, I would ask you if it's possible to table this for the simple fact as the liaison with the planning board. To look into first, to see who this would affect, how many businesses this would affect, before you go opening up the can of worms.
Yeah.
So before this continues, can this be withdrawn, pulled, tabled, and find out the information first before we do this? This entire meeting here tonight has been attacking businesses. This entire meeting. Everything that comes through the planning board when it comes to businesses, I can only speak on the behalf of the 2 years. 3. We try to do everything in our power to dot our I's, cross our T's, so that we avoid litigation. I can't even imagine the litigation that's gonna come out of this. So please, all 5 of you up there, table this. See how big this is, because this is huge.
I'll make a motion to withdraw this resolution.
I don't know about withdraw, but I'd make a motion to table it.
Yeah, I mean,
For
and
further discussion?
I don't know that you got a second.
what can I respond to Ms. Grogan? Yeah. Ms. Grogan, I can assure you, I mean, you might be perceiving it as attacking industry, but I would say it's more about trying to find a balance, trying to follow the comprehensive plan that was created in 2020, And, everybody, we've heard it for the last several years, and you guys even more, but it seems to be one of the biggest issues with the town is trying to find a balance between industry and residences. So, we're trying to find that balance, and where there were things that maybe led, industry to creep over that line, we're trying to possibly find solutions so that we can live cohesively together. Now, I will agree, maybe going back 15 years, so be it. But I also think if that wasn't in there, if that, clause 2 was taken out, what's that?
I could just, because I did contemplate some of these sort of arguments being made. If you eliminated 1, 3, and 4, clause 2 essentially asks the building inspector to come back to us with that input of what did not get site plan review that I would say should have, but I'd leave that to his determination.
And can I ask you honestly, what is that gonna do? What is that gonna prove?
What is
A lot of people mad.
Review.
It's gonna make people mad.
What is that none of you sitting on that board, myself, Al Collins, none of us had anything to do with that. I understand your position on bringing this forward to make sure going forward it's done correctly.
Right.
But none of us are at any responsibility for this, and if it is not harming anybody, it is not causing anything trickle down. Why?
Well, how do you know it's not harming anybody if no site plan review is done?
Because we're living it.
But we get a lot of complaints too as a town board members. We get complaints from various people.
All we hear is truck traffic. The number one thing that I've heard since I moved back here in 2019, because I wasn't here when the trucks started to go from what was it, 2011 when they went through 15 trucks coming out of Amrise in the town board?
In the early 2000, Amrise, then I think Laverge submitted an application that would have required, or would have generated an additional maybe dozen trucks to sort of ingress and egress onto 9W. The town's response at the time was a traffic study that, was probably more than 200 pages. And so, there was a time when the town was looking at this. For whatever reason, over the past several years, they have not. This is, I believe an appropriate interpretation of the current sort of state of the law, but ultimately it's a policy decision for this board to decide how you want to proceed or not.
So just to ask a question about the truck traffic, I'm here not on behalf of Amrise or Heidelberg, but I know a little bit about it. That quarry has been around for longer than many of us have been alive. They have been quarrying hundreds of thousands, if not millions of tons of rock out of that quarry to make cement and to sell through different processes over the last 50 plus years. What in this law that you are changing would change the trucks coming out of the quarry and delivering aggregate? That use hasn't changed in 50 years. They have done more trucks or less trucks, and now it is in a state of higher. But none of what you have on this piece of paper, from what I heard, would change Heidelberg and or Amrise's ability to quarry rocks in the quarry and truck them onto the road. Site plan review wouldn't apply to that because it's an existing use for the last 40 years.
It's an expansion of a use, and it was in fact an expansion. In 2016 and or 2020, they actually had to go to the state of New York and get an expansion of their mining use permit to be able to do what they're doing now. The paperwork from the state of New York that granted them that expanded mining use permit made clear that it did not relieve them from the obligation to go through any applicable local approvals.
Certainly, but the use didn't change. So what would trigger site plan?
The expansion.
Expanded.
So that's what you're going after.
So why can't
Not going after anybody. We're trying to maintain.
It's so obvious.
Ms. Collins, here's the thing. You live on 143. We've had meetings with people from the village, people from Mountain Road Extension who get 100 some trucks a day. Like,
There's been daycare in the
Mike,
village, they
what,
want.
Zach?
She's well aware of the truck.
Oh, I know. She's saying your own effort. I'm not going. I'm trying to try to solve a problem, Zach Collins, regarding the truck traffic. It hasn't been done yet. So hold on, let me speak. All we're saying is, for example, like they expanded their business, they expanded their truck traffic. They should have probably come up to the zoning and planning board to have a site plan review because they're expanding their business.
But again,
To
so
see the effects on their residences.
But this is.
What's that, Zach?
weren't here.
What's that? I wasn't here?
In 2016, they expanded their business.
So it's done.
So you want to go back and
So-
say, everybody who made a decision before then, 15 years ago, I'm getting affected by it now, and everybody else is gonna pay. Those are the two things that you put up on the docket tonight.
Zach,
It's the
That
same
is
thing
a
as the first,
shame.
it's the same
Zach,
thing as the
that is
public
a
you know
hearing.
and I know, Zach, that's false.
Oh,
Okay.
really?
How?
I would
For somebody who
argue
wrote the
that if
comprehensive
shoes on
plan,
the
my
other
friend,
foot,
you better
I
practice what you
would-
preach.
The comprehensive plan was
Is
in
what?
2020.
Yeah,
This all
5
happened.
years ago.
It's actually from 2006, and then there were amendments in 2020.
Why can't you go back through from 2011, pick up all the things that are wrong, and from here on, they can't do that?
You have to do
Why can't
it
you do
moving
that?
forward, you can't go backwards.
And
I
just
mean-
to reiterate it one last time, if you think something is wrong, that is part of your law, and you want to change it, there's a process to change your law. You
Right.
can't just start throwing resolutions out because you think something that somebody did 15 years ago, or 5 years ago, or 8 years ago doesn't match your agenda. You don't get to just pass resolutions to change the law. That's the way this system works to protect.
The point has been made that the law was put in place in 2011. So whatever happened from 2011, whoever didn't enforce it, whomever was sitting on the board and didn't say 150 Carver trucks at the time, now Heidelberg, it's only 20% according to their numbers, 25%. There's still 75% trucks, salt trucks coming out of the industrial park. There's what, 19? How many tenants are at the industrial park?
More than that.
More than 19?
Yes.
All of them, they get heavy truck traffic? Or just
No.
half of them?
Some.
Right. So how many trucks are coming out of there?
There's all
Is
sorts
there
of different
a
things. We also did a
study?
full environmental impact study for the port second dock and the Poway project. We spent 37 months and 15 days going through that process with DEC as lead agency. They reviewed everything, they approved what we did, and we got approval from the town board as part of that, and the planning board. All of that is approved.
What year was
You
that?
don't, 2022, in January, we got that approval.
2022.
Yes.
But the fact
You
you're
on the
gonna.
board in
you're gonna
2022?
do this without
Help with
even
that project.
consulting
I was the
them?
chairman.
It's not complete.
Well, no, the 2022 one was complete. You were
Oh,
the
the
chairman
Poway.
of 2024.
And we,
I was the chairman
Clear.
for the 2022, and I had numerous discussions.
hang on,
D.
real quick. We don't think a resolution this heavy deserves a public hearing?
Yeah.
Whoa, that is scary, guys. This deserves 3 public hearings.
Right.
3 public
You
hearings.
gonna go back that far?
I'm just
To go
blown
back 15
away.
years and give you guys that power and you don't think there's a public hearing?
We're going off of the town board that came before us that made that law. We've made that point several times tonight, that you should try to understand that that already exists.
You
This is
should
a
try and
heavy
understand how many
resolution,
site
sir.
plan
This
reviews
is
we
a
went
heavy
through before you
resolution.
claimed that we had none.
So, Mr. Donnelly, can I ask you a question? And I really hope I can get an answer. Living in this town for over 20 years, sitting on the planning board, usually change gets made when there's an issue. Truck traffic on my road at 55 miles an hour. I came before this board 3 times to get my speed zone changed. What was presented to this board that brought all of this up?
Truck traffic. That's
No, you brought that up. You brought the truck traffic up by doing
Residents
the
brought it up
resolution.
to us.
No. You brought the truck traffic up at a couple meetings ago by putting a resolution forward to change the limit on a road. That's how that truck traffic came about. And I don't disagree with you. Truck traffic is an issue. And I thought this board was trying to do something with truck traffic alone.
than your
This
paint.
is not truck traffic.
It's where the trucks come from.
This is not just truck traffic. I'm reading this. This is not truck traffic. So, again, I would love to know what resident, what business owner, what person came to your board and said, this is an issue, can you look into it? How did this come about? What person brought this to this board to look into this?
Person brought it to the board.
That's what I'm asking for. What person brought this board? He's saying the residents.
I raised it with the board, right?
You're saying the residents. I'd like to know.
Come up, we bring them to the proper department. This happened to be a legal department issue. We had them look into it. They found issues. Now we're having the discussion to make.
This is not a discussion. You are getting ready to vote on this, and I can't even tell you what you're going to do to my board, the members on my board, businesses that are in this room. So this is not a discussion. This was not a workshop. This is not a public hearing for that. This is, let's take action and make this a thing. And I don't disagree, Mr. Riley, I don't disagree with any of you. I don't. Take this, rip it up, throw it out, and come back to the table when you can have open discussions with me as the chair, the other members on the board, the people this is going to affect. Please. This is insanity. You want to punish and penalize businesses and other people for 15 years ago? That's insane.
I find it interesting that you're gonna go back 15 years and penalize businesses, but you won't go back to January and fix my deputy's resolution.
And just for the record, from our perspective, most of the people, if not all of the people here are here because of the public hearing that you scheduled to discuss agricultural terminal.
Trucking terminal, agricultural.
I truly believe, and I want this on record, that none of us would have been here if it wasn't for this, and you guys may have just passed this resolution without any input from all the people that you were trying to attack.
I would have still had my comments.
Steve would have definitely commented on it.
I'm sure he commented on everything tonight, but at the end of the day, this was done underhandedly.
Well, I appreciate
you guys keep using the word loophole as to us using the zoning law, but what you did here was underhanded. You did not public notice this. You are trying to attack us for the last 15 years of our development in this town, and that is not right.
Mr. Larry, I appreciate you showing up because I actually appreciate you getting that information regarding how the process should work. And regardless of that it may have been done wrong in 2020, this board shouldn't be doing it wrong just because it was done wrong in 2020. So I appreciate you bringing that to us. I am not a supporter of the transportation terminal definition thing as well. And, you know, I appreciate everybody coming out and expressing their opinions. I also think that we should possibly have some type of, our ethics committee should look at whether or not we should have a member recuse himself from voting on it. So I think as a board, we should look at that.
Are you referring to me, Ron?
Yes, because it's been brought up that, yes, because it's
Mr. Riley, let me ask you a question. I mean, legally, is that something somebody recuses himself for?
Because the property borders Mr. Powell's, and again, I think that we should at least have it looked at, because if we're gonna get sued, I wanna make sure we're getting sued for the right reasons, not because we did it wrong. So.
Well, thank you, Mr. Hoteling. Ms. Grogan, I do agree. I'll second, I think we need a second for your motion, right? So I will second it. And again, I feel like we definitely can look at that. I mean, as far as, and this is my own personal opinion, as far as, the exceptions for the principal uses, I think, I'm not for those being exceptions. I think if you're going to have special use permits for the other zones, then surely why wouldn't you have it for industrial? But as far as the part two, yeah, we can talk about it. Sure. I mean, it's okay.
And that's a fair statement. Saying that maybe there should be a site plan review, but to sit here and put people on high alarm that you want to look back 15 years ago, that's just wrong.
Yeah, it's certainly. Once again, we're just looking at the board in 2011, the laws that they passed, the way that they were going about protecting the comp plan.
But Mr. Donnelly, you're doing more. You were going to vote on it.
And you weren't planning on having a discussion. It was just unfortunate that we were here to talk about something else, and we turned into a discussion.
Not that unfortunate, it's actually really good.
Correct. But you're sitting there saying it was a discussion. It was not a discussion. The discussion was the public hearing. The open business is the discussion. The resolutions are things you generally plan on passing. You don't usually table something unless you're planning on voting on it and voting in the affirmative. And I would request on behalf of Carver Companies and every other industrial user in the town of Queens that you look at changing any of these things written in the zoning law without going through the process of a public hearing and consulting the planning board.
Well, we're absolutely gonna have more discussions with Carver Companies, you and the PBCBA,
Thank you.
as you requested.
So there's a motion to table, a second.
All in favor?
Aye.
Very good. Upcoming meetings, November 24th is our next town board meeting. That's a Monday because of Thanksgiving. PBZBA has their next meeting on November 25th and December 28th, both at 7 p.m. And we have another town board meeting on December 11th.
And just a reminder that the November 24th meeting is a Monday night,
Right, Dennis?
so.
Oh, also, December 9th, did we nail down for the town village?
I gotta check with them.
Okay.
I'll get back to you tomorrow.
It's the joint meeting.
Try to.
We have to talk to the village first, possibly December 9th, possibly. If it's accepted by them, I'll email you and let you know.
Who's hosting? Who would host?
They're gonna host.
Public comment time.
Well, public hearing.
Still on the public hearing.
Okay,
I
gotcha.
can just make a suggestion. Once you're done with public hearing comments, maybe close that.
And do public.
And I'll make it quick.
Yeah.
Again, right, Lukens is here, Collins is here, Beers is here, Mike Stanton's here, right? All these people from the Howl, they all have humongous farms, successful farms, they've been in farming forever. I'll give you two examples of how, if you guys pass this law, it's gonna cripple these farms, because it's not an accessory use. Dave Flack's farm, do you guys know where it is? Does anybody on the board know where it is?
Yes.
Okay. They do motorcycle racing there, right? Why do they do that? Because the farms are dying. So if you change this law, he's done, right? Bucks Ranch Road, do you guys know where that is? Right? They have a little farm up there. They try to have concerts up there. The planning board put them through the ringer. Put in a emergency road, have a nurse on standby, bring in 35 bathrooms. All they want to do is have a concert there.
It's a large concert, large.
Okay? They're trying to sustain their farms and stuff. This will cripple them. So please do not vote this through. This will cripple people and the ability for these farms to expand and do something different. It will cripple them. And again, I'm sure Stephen Flack will be in your office saying, hey, what are you doing? They run motorcycle races up there on the weekends. That's their, revenue. So if you make that agriculture only, motorcycle racing is not agriculture. Thank you.
You're gonna close, no, they're gonna close it.
No, I honestly think that we should keep it open.
Okay. Well, these guys got public comment.
That's my position, is that based upon,
One to start the other, right? I mean,
you don't have to,
Public
you
hearing.
don't have to close this public hearing. We can keep this public hearing open and we can continue it again
Sounds fine.
at the
Okay.
next meeting.
Public comment.
Public comment,
Another
yeah.
meeting.
We-
Okay.
Well, we still have to act on that, so.
Good evening. I'm not sure where. Start at the beginning. My name is Scott Olson. I'm an attorney with Young Summer. And so we recently submitted, I don't know if you have the material. I represent the Dorseys. We submitted a request for a local law that would amend the zoning ordinance, which obviously has come up earlier. And I heard Mr. Hoteling's comments and some others about why do this piecemeal. I understand it. I would hope this board would consider it because we're not asking for a new use to be added, or we're just asking basically, can the town board consider changing the law to add definitions to terms that are already in the law? Because it's creating some ambiguity, especially for my clients. Sorry, what? Oh, sorry, I thought I had a question.
No.
So as you may be aware, my clients, they own the property at 880 Bridge Street. Right? That front's in the town of Bethlehem. Back part of the property is in the town of Queens. They pay taxes to both towns for each use. The property used to be owned and operated by, what is it,
Oakencroft.
Lesser.
Anyway, so obviously you know what that is more than I do. So in the back part of the property, they have a barn. They started to renovate the barn. They were under the understanding that they didn't need a building permit. Long story short, they did go and apply for the building permit. I think maybe the building permit got filled out a little, the application incorrectly. It got denied. Unfortunately, I just said to them, and then I got involved and I said, hey, just preserve your right, file an appeal with the planning board, ZBA. They did, we went through that process, and as of Monday, the ZBA basically upheld the appeal. We think what the Dorseys want to do on the property, though, falls under the permitted uses. I mean, it's in the RA district. You know, general farming, residential facilities, riding academies, those are 3 permitted uses in that district. Now, what they're looking to do, some traditional farming, raise, horses, cows, pigs. I think everybody agrees that's farming. Harvest crops, but they also want to diversify the use. And I think you've heard a lot of comments about farming and how it's a dying breed. It is. And last year alone in the state, 2,100 farms went under. They went away because they couldn't support themselves. So New York State basically acknowledges that farms need to diversify. And they call it agritourism. Have people come for, pick your own things, hay rides, farmers markets. New York State now says that should be included in general farming. Now, it may not be traditional farming, but it's kind of the new modern farming, because if we don't have that, farms will continue to die. Across the country, in this state, in Queens, everywhere. So they want to do some stuff like have farmers markets at the barn. They want to do, food. I'm sorry, I'm losing my thought.
Farm to table.
Farm to table, where they basically partner with other farms in the area, showcase their products. So have dinners there with those farm products. Again, that's part of agritourism. They also want to use the barn for farm type themed celebrations, weddings, birthday parties, that sort of stuff. We believe that, and I believe after reading your code, they could do that today. Because, I would ask, it falls under recreational facility. But then you say, well, what is a recreational facility? And I can tell you, I don't know, there are 50 people in this room, maybe 50 people say 50 different things. So what we're trying to do, we're asking you, could you please consider providing a definition for general farming and for recreational facilities? And I wrote it up so that it's pretty broad, and I think recreational facility is pretty broad, so that it would cover what they want to do, what a lot of people want to do. I've taken the liberty to at least propose a draft of the 2 definitions that we're looking at. So that's what we're here, to talk about. I believe the Dorseys were here last month or so. I could not be here. So, but I appreciate the supervisor inviting us to, come and talk about this tonight. And I am certainly happy to answer any questions that you may have, if you have any.
Well, Mr. Olson, I do appreciate you coming today, especially at such short notice. I did see the email chain with the supervisor where it was encouraged, or you said that you could be available during our next meeting. So I do appreciate you coming here today. I also do appreciate you providing us with a draft and some language for us to work with. I'll be honest, I didn't have time this afternoon to dive deeply into your proposal, but I certainly will look at it and look at it thoroughly.
Yeah, we appreciate that. Thank you.
Thanks, Scott.
Okay. Will the board be in touch with us? I know there's another meeting on the 24th. I cannot be here, but I guess I can contact you, Supervisor, if it's okay.
Yeah, this sounds like another conversation with Planning Board, Zoning Board of Appeals, chiming in and letting us know where they're at.
Yeah, well, where they're at is that they upheld the denial. But I think that if this board wants to take this up, I do agree, I checked quickly what some gentleman said earlier about that the planning board would have to give a recommendation prior to any type of public hearing. But that's what we're hoping for. We're hoping that the board will at least entertain it, send it to the planning board, and have a public hearing. Because without having definitions, it creates some ambiguity. It creates a situation where, existing landowners and prospective landowners can't predict what's allowable in that zoning district. So, and that's when the Dorseys, purchased the property, farming, and with the modern trend of, agritourism and that sort of stuff, they thought we could do this without a problem. And then, I think they can, but we are where we are. And I would just also add that it is consistent with your comprehensive plan. There is a section in there that talks about agritourism. It's also talks about a lot in your economic development strategy plan of 2007. Talks a lot about that. So we think it's consistent. So.
Thank you.
Thank you.
Yes, thank you.
And to the board, this is the case I was telling you about that we as a planning board just denied, which is why all of the zoning needs to be redone. For this reason alone, their case that they brought, so, and our planning board did let them know to try that use variance. So simultaneously, try.
I hear what you're saying. As an attorney who spent way too many years in zoning, use variances are next to impossible unless you're a cell tower developer like I am, because it's impossible not to get one. But I hear what you're saying. The only thing I would say to that is, yes, maybe your zoning needs to be rehauled. I'm not going to tell you it does or doesn't. All I would say is hopefully maybe you could do an exception for this request because it's just adding a definition to terms that exist. You're not changing uses. And a rezoning or zoning amendment, it takes a long time. I mean, I'm just listening to things here. You're looking at 3 years, if not more. And so we would just request, we would hope that you may at least consider accepting us from that long process and maybe do a local law. But thank you.
Thank you.
Can I just point out, going to the public hearing real quick, that this is a perfect example of why the language is so broad, because farms need to do these types of things to survive. And some farms might do a venue or a farm to table. Some farms might do trucking. Some farms might do, other things. It depends on what equipment you have and what space you have. But this is a perfect example of why narrowing the language down is going to make it so much harder on these farms to stay functioning.
And that local law you're presenting will decimate the Dorseys for the plans that they have for the future of their property.
Absolutely.
So it's good that we're having this very large discussion between industry and farming and, as Mr. Laraway pointed out, commercial in between. Is there any more public comment?
Going back to the doctor's office, you guys indicated that there was a $20,000 change order for the cable. Does that fall under the procurement policy where you maybe should have got a second quote for that?
No, we're going through AOW. We looked into that.
Because what if they said 50 grand or 70 grand? You guys have said, okay, go ahead and do it?
No,
Doesn't it require?
It would be a change order to their contract that this board would have to approve or not.
Don't you think it requires a second quote though? And why wouldn't you ask, hey, can we get another quote? It's 20 grand. No? No, Linda?
More of a,
I didn't think
more
so.
of a timing
It's the
issue.
same, it's Edmonds, we got Edmonds
I
in.
mean, usually when you're doing work like that, they come to you and say, hey, it's 50 grand more. You're gonna say, okay, here we go.
Well, the next thing is we tell people, no, you can't use your computer or your phone there because we're only.
I'm not saying that, I'm saying,
That would be it, then we
yeah,
could.
that wouldn't be it. You'd say, you know what? I have another cable contractor. Let's get a quote from State Telephone.
Right.
That's what you guys are responsible to do. You're spending taxpayer money.
Yeah, and we've saved $160,000 so far by using AOW and LeBurd.
That's great.
It
But
is
now they're coming to you saying, we want 20 grand.
Right. Well, we're also under a deadline, Dan.
If somebody came to your house and said
We're
it's
under a
20 grand
deadline.
extra, would you say, okay?
Correct, but you need to know we're under a deadline.
You set the deadline, not me, you did.
No, our lease agreement sets the deadline.
I'm just saying, don't you guys think that it's worthy of getting a second opinion, a second quote? I got 3 quotes for the trucks. I get quotes for the mowers. I get quotes all the time.
Yeah. Thank you.
When is the deadline?
31st of December, we have to be.
December 8th.
Now, you're gonna move in, hopefully, that's.
On the 8th, and we still have to move and put everything and hook it all up. So, yeah. Very tight deadline. Further public comment? Public hearing still open? Anybody?
So there is a couple observations. One, if at any point you do decide you want to proceed, we're gonna have to schedule another public hearing anyways. If in the interim you want to keep the current public hearing open, I would just recommend a motion, I guess, just to formalize that.
So I suggest we keep the public hearing open. I don't know what the rest of the board thinks. but
Yeah, that sounds
that's fine.
great.
I second that.
So I'll make a motion that we leave the public hearing open for the local law number 1 of 2025, the proposed local law number 1 of 2025, open until our next meeting, which is
24.
November 24th at 6 o'clock.
Yeah, I'll second that.
All in favor?
Aye.
Can I just clarify?
It's gonna be open through you closing it at that next meeting. It's not like it's,
We don't have to reopen.
We have to
the
reopen
way
it.
it was worded, it's open until the meeting, but it'll be
It's open through.
whenever you close it.
And that was my next question for you. If you're leaving this public hearing open, and then you're going to close it, you are going to repost a new public hearing?
Oh, absolutely.
Okay, thank you.
Okay.
We posted a new public hearing for the 24th,
No, for what,
when we decided to go back and forth with the,
yeah,
yeah, okay, I just want to make sure I was clear what you're saying.
exactly, thank you.
Any further discussion? Okay, I'd like to make a motion to go into executive, what?
Executive, if I could, I would add a comment once that motion is made.
For legal advice on a FOIL appeal. And that we
And
will be,
also just suggested, if we could, I'd like to have a discussion about 2 contract negotiations and a personnel matter.
okay,
There'll be no action on the contract negotiations or the personnel matter. The board will need to take an action in connection with the FOIL appeal. There's a hard deadline for that, and you need to act on it.
And what specifically, under New York State Public Officers Law, Article 7, Section 105, are we going into executive session?
For the 2 things I just mentioned would be contract negotiations and personnel matter. As to the FOIL appeal, it's really to receive legal advice from your town attorney, which you can always do. In fact, you could do even without an executive session, but that's what we're talking about.
For the audience's clarification, there's no more discussion about land use. tonight, right?
None whatsoever. Nope. The only action item will be on the FOIL appeal, which we have to take action on tonight.
need a second?
I second that.
All in favor?
I'll stay out here, everybody leaves.
Still here.
Everyone's gonna leave, you stay here. Prefer to stay out here, guys?
good legal in connection with a FOIL appeal that has been submitted to this board. As the FOIL appeal officer, you now need to make a determination. It's my understanding that the board's determination is to authorize the village attorney to issue a denial of that FOIL appeal.
Not the village attorney.
Excuse me, the town attorney, based in large part on the findings that the town clerk had made. And we will prepare that determination and send it out if that's the board's inclination.
I'll make that motion.
Second. And that is our determination.
All in favor?
All in favor?
Aye.
Yeah, make motion to adjourn then.
I'll second.
All in favor?
Aye.